Lordship, may Lordship, I beg to mention item number 4, Lordship. Item number 4, Lordship, I have some matters in court number 1, Lordship, which have been fixed. And I have to be there, Lordship. So I need a accommodation for 1 week, Lord. Day after tomorrow, there are some other matters fixed in court number 1. Yes, Lordship, I understand, Lordship. I with difficulty I am doing it, Lordship. I was not about to do it. But some senior officials have come from the Mizoram and I have to be there.
But we cannot
Next week, anytime, Lordship. Next week, anytime.
connect you
Next Tuesday, fine.
both for the other side.
Other side, Lordship, I have not.
Perfect.
I could not contact
Let
Lordship.
them come, we'll pass the whole
Lordship.
matter. We'll accommodate you next Tuesday. We'll
Lordship,
pass orders in the press.
Lordship. Oblige,
Madam Pura Gohan is Paul Gohan.
Borgo, I could not trace out, Lordship.
Is the other matter perhaps?
Lordship may kindly accommodate for a week. Oblige, Your
Merpage Lordship, I pray for listing of a matter tomorrow, my lord. It was lastly listed on 15th. Lordship, transfer matter, it was Lordship had fixed the matter after a week. The matter has not come up.
Ben's pre-matter.
Yes, ma'am. Lordship, on last 15th, it was listed before Lordship. It's a transfer matter, otherwise it will become infractus.
There's an interim mode.
No. It was on the last day, I was out of station below, adjournment was stopped. And Lordship had fixed the matter after a week. The matter has not been listed as thereafter.
It was on 15th
15th.
for motion.
Promotions.
Meet is a lot of I'm making this prayer for listing of this matter tomorrow for motion.
Motion.
Yes.
Filed already.
Yes, it is already. And there is another prayer for listing. It's an introductory application, my lord, paying for implement. It was filed on 2/9/2023.
Friday?
Friday. My lord, there is another prayer. You know, item number 13, my lord.
13 years.
Item number 13. One payment. My lord, today, my lord, I have some personal difficulty. My lord, can you please stay after tomorrow, my lord? It is convenient to lordship. Day after tomorrow.
The Chaudhary is not there.
Yes, I am assisting him, my lord. Today I have some.
Okay, they have.
I'm deeply obliged.
Is there any urgency?
There is some urgency, my lord, due to pendency of this, my lord. If press so cause notice, my services have not been confirmed, my lord.
Just those for the other side.
The government advocate is
Item number 13. One of their made by RM Dekha. On
interim may kindly be continued till tomorrow.
more past.
I'm deeply obliged.
Madam Borgohai. Item number 4 next Tuesday. Is it okay? We have not
It's
passed
okay. I
you.
do not have any instruction from my client if I expect.
Okay.
I've lost control.
Next Tuesday with the
Lordship. Yes.
prayer. Must be equally tested. Any contest with commerce department. Praise for us. Short accommodation. There are considering that matter of that so the matter is adjourned. That under the call of proposal or Tuesday. Three, two.
Yeah, please, Lordship. Lordship, I beg to mention, my lord, for listing and tomorrow morning, it's a matter of transfer, my lord.
Motion matter.
Lordship.
Filed already.
Yesterday I have it.
Ben's free matter.
Lordship.
Ben's free matter.
Lordship.
May it please, my lord. My lord, I beg to mention a matter for listing, the disciplinary proceeding matter.
What is the
Yeah.
stage?
My lord, admission stage. Sittings are over.
Matter of which year?
My lord, 23, my lord.
Matter why it's out of turn list?
My lord, there is some urgency in the
Urgency, what kind of urgency?
My lord, actually, there were certain infirmities in the disciplinary proceeding.
That is not an urgency. That's merits of the case.
My lord, can it be taken up from second, my lord? If it pleases,
No, we cannot just allow a mention. The mention is only for urgent matters.
Right.
It's listed in its own course. Otherwise, matters are not listed.
highly obliged.
May I please, Lordship. I beg to mention for listing, Lordship, contempt matter, Lordship, for orders, any date, Lordship, next
Why?
week. The urgency is that the petitioner has not received his salary since the year of 2020, Lordship.
Contempt. Will you
Yes.
receive salary in a contempt matter?
No, Lordship, order was passed in the read petition, Lordship. Then thereafter, his salary was not, he has not received his salary. Then again, we have filed a contempt petition. And it's
So in a
orders-
contempt matter, will you receive salary?
Yes, Lordship.
In a contempt matter, are you expecting an order for receipt of salary? Sorry, next.
Lord, I beg to mention item number 1 of today's this Lordship matter is of 2013.
Yes.
Last matter was last listed in the year 2018 Lordship.
Hmm.
Matter pertains to deduction, illegal deduction of the salary of the petitioners Lordship in the name of supplying uniform. Now Lordship, the present status I am not aware Lordship. I need to take instruction in the matter. Whether
Yes,
this
My lord,
petitioner.
this matter can be closed because we had admitted, forest department has admitted that whatever was done, it was illegal. And my lord, the person against whom these allegations are coming, he was an APS officer without not in our control, my lord. And inquiry have been instituted.
Okay, what about the IA? IA?
Go on perpetually, my lord.
No,
because it's
what
done.
about the IA?
I don't have the copy.
No,
don't-
IA is by one
to tell
Jayashree
you.
Khersa.
It's filed by them.
If I may, Lord, to appeal for respondent number 5, your Lordship. Lordship, if I may, let the petitioner take his instruction to Lord. Document with the
No, day after tomorrow will be short because I tried to contact them.
No, what the going saying that the matter has been sorted out.
Even we need to be required to take our instruction. Correspondent.
There is an admitted pleading by the conservator of forest that illegal deduction was done without following the
Now,
rules.
has it been remedied?
My lord.
What have you done to remedy?
Well, there has been sanctioned, my lord. I had gone to the affidavit filed with joint secretary and the conservator, my lord. That proposal has been sent, my lord. I have to also, he has to take instruction that they had been paid or not.
Principal secretary appeared before the court and submitted that she has already been show cause lordship and there is a direction to initiate criminal proceeding. Against that order, they filed a writ appeal. As far as the initiation of criminal proceeding was concerned, that part was set aside. But show cause has been initiated against this person.
What is you appear for that?
I have to for
Officer.
respondent 5, your Lordship. Lordship, putting to particular.
Person of 5 is their officer.
Yes.
What about the
That they have to, government has to answer, my lord, because
No,
he
no,
is an
no.
APS officer.
what is stage of
For that, I will require.
That
not you?
That we couldn't say, my lord, because it's APS officer, my lord, not within our control, my lord. Government has to answer that.
APS.
APS, my lord, one deputation, Jayashree Khersa, my lord, APS, she was in deputation in Assam.
Oh, she was not a for but
No, she was not a forest officer.
yes, Mr. Chakur. Mr. Chutke, you are there?
APS officer.
No, we are not taking this matter today. We'll give you some time. Get the instructions what is the stage of the disciplinary proceeding against this particular officer.
What is the fate?
Some this APS officer while in deputation in the forest department
yes.
had directed deduction of from salaries for some uniform supply. So, but the department has said that there is no such authority, and department in fact has initiated a disciplinary proceeding against their officer to head order. We want to know what is the stage.
Yes.
Can we have it on when? On Monday, the holiday, on Wednesday
Wednesday.
next Wednesday. Get more than a week.
Really difficulty, let it come up after 10 days, Lordship, because I have not been able to contact the
Next Wednesday.
Wednesday.
Uh,
Let it come up on Friday then. Lord.
2013.
I don't know.
Prayer has been made on behalf of the party with regard to the present for behalf of the party for right accommodation to enable the enable the learned council of the instructions on the present stage of the case as well as the department proceeding against the respondent of filing. Consider that matter is of the year 2013. A small accommodation is granted direct case on Wednesday date. Put under the column top of the. This will be item number 1.
May it please your lordship.
Yes.
May it please your lordship, I beg to mention for listing of a writ petition pertaining to promotion of a Anganwadi helper to worker.
Writ petition for motion.
Promotion for Anganwadi helper to worker.
No motion you have you filed. When have you filed?
Pardon me, Lord.
When have you filed?
Last listed was 21/9/2020.
22.
Yes, sir.
Is it for motion?
Yes, sir. It is for admission, Lord.
Admission?
Yeah.
What's the urgency?
He might be retired, Lordship.
When?
Lordship. I don't know the exact date. I will confirm
No, when? Period. Tell us the period at least.
in the next couple of
Come
months.
prepare, not come like this. Coming with a mention memo without knowing the facts. Don't encourage. Sorry. Yes.
May please your lordship, I beg to mention the list from the court number 2, my lord Justice L. Jamil lordship.
Hmm.
Lordship will find 56 items.
Yes.
Lordship, it relates to pension lordship. This matter may list on 29th, Lord,
29.
Friday.
But
Pension matter.
the records are not.
Sure.
So the list is there that urgent matter can be mentioned.
Lord.
Records are not there. We will not be able to pass the order.
Lord.
If the records come, we will try to accommodate.
Lord.
Just give the details to our court master.
Lordship. Highly obliged.
May it please your lordship. I have a similar prayer, lordship. There is a series matter 1 to 42
In
Court of Justice Al Zamir, court number 2. The only issue is that these matters are pending since 2017. This relates to the payment of salary. Now, there was a direction from this honorable court on 59/2023 to produce certain instruction or else personal appearance will be directed against the officials of the elementary finance and the BTC department. So may I pray it's not today, any day convenient to your lordship?
records are not. If the records come, we will try to accommodate. Yes.
May please your lordship.
Deeply obliged.
It's a matter of 2017.
You inquired the court master. If the records come, we will try to.
Deeply obliged.
As a matter of 2017, I am prayed for listing of next week, any date, my lord.
17 matter.
Matter.
What is the matter about?
My lord, it is the selection and appointment of the my lord, APDCL workers.
Okay, we'll have it on Friday.
My lord,
Friday. This Friday.
no, not my lord. My lord, it will come on orders, my lord.
We'll have it on this Friday.
This all published.
May please your lordship, I wish to mention one writ petition. From last to date, this matter was listed but stands left over.
Matter of which year?
2022.
What matter? What is the subject matter? What is the subject matter? You do not know the subject matter. How can we help you? You should come prepared with little bit of fact. What relief are you seeking from the court? Come prepared with the fact. Minimum fact. Yes.
Very powerful. Maybe your lord. But if there is desire to know the status of the chairman BOG with regard as vis-a-vis the institute. Lord. Right? Now, what I
You
just
make your
point out,
arguments.
position the records statute may I point out, Lord. That will be helpful for many Kamari. Section 10 of this Act, Lordship. Section 10 of the Institute Act,
You are for response number 7.
Lordship 7.
Section 10.
Section 10. The Lordship, what is that?
Yes.
The following shall be the authorities of an institute, namely, institute is the IIT Guwahati, Lordship, the Board of Governors, Senior and Session Judge. Board of Governors, Lordship, the chairman is a part of the Board of Governors. In the next section, Lordship, you can list 11, section 11.
The Board of Governors, the board of an institute shall consist of the following persons, namely, the chairman to be nominated by the visitor.
Yes.
The chairman is a part and parcel, the integral part of the Board of Governors. Now the board's power, Lordship will kindly see section 13.
One three.
One period.
Yes.
Subject to the provisions of this act, the board of any institute shall be responsible for the general superintendent's direction and control of the affairs of the institute, and shall exercise all the powers of the institute not otherwise provided by this act. The board controls everything of the institute. Okay? A board is headed by the chairman. Again, 13.2, Lordship. Without prejudice to the provisions of the subsection 1, the board of any institute shall take decisions on questions of policy relating to the administration and working of the institute. So everything is decided by the board, Lordship, and headed by the chairman. Then Lordship, 16.1, Lordship, section 16.1.
Yes. Yes.
The chairman shall ordinarily preside at the meetings of the board and at the convocations of the institute. It shall be the duty of the chairman to ensure that decisions taken by the board are implemented. The chairman shall exercise such other powers and perform such other duties as may be assigned to him by the act of the statutes. Then section 27, Lordship. Section 27, Rule 2, Lordship. The board may, from time to time, make new or additional statutes, or may amend or repeal the statutes in the manner hereinafter in the section provided. That the board will make the statutes under which it functions, institute functions, that is also determined by the board. And the statutes also, some provisions are there, Lord. The statutes got it. Right. That's the statutes collect.
Yes, we have. Which page?
Clause 2.5.
Page.
Statutes, Lordship. Page 2. Page number is given in the bottom of the page.
Yes, 2.
Page 2. Clause 2.5, chairman
Yes.
has got. Okay. Two five, Lordship, is text. It's all about the board.
5.
All, Lordship.
Yes.
All questions considered at the meetings of the board shall be decided by a majority of the votes of the members present, including the chairman. If the votes be equally divided, the chairman shall have a second or casting vote.
Yes.
Then 2.11, Lordship, on the same page. The ruling of the chairman in regard to all questions of procedure shall be final. Then clause 7, subclause 4, at page 10.
7.
Clause 7 of subclause 4 of the statute, page 4.
A written notice.
At page 10. At page 10, sorry. at page 10.
7.4, in the emergent case,
The emergent cases, the chairman may exercise the powers of the board and inform the board of the action taken by him for its approval. So this is the status of the chairman of the board vis-a-vis the statute or vis-a-vis the institute.
Yes.
Represented by the registrar now. Now on the merit of this case, present case.
Yes.
Merit of present case, that IIT Guwahati represented by its registrar has got in fact nothing to do, Lord, because order impugned is the order passed by the later issued by the secretary of the ministry, Annexure 2, and the secretary of the ministry is represented by their council lordship, Central Government Council
your order is not put to challenge.
lordship.
Your action is not under challenge.
No, we have no action in the whole affair. We have no action.
No. The action which has been put to challenge, you have got no role in that action.
The action that is only we communicated it only. By Annexure 3,
No,
we-
communication is not, we are asking. In the decision-making process, did you have any role?
lordship.
In the decision-making process, did you have any role?
We have no role at all. Lordship.
IT doesn't have any role.
IIT Guwahati represented by registrar has got no role.
Can you consider your argument to mean that whatever decision was taken by the chairman was on his personal capacity? You don't own that decision.
Chairman is taking the decision, lordship, that he is represented by the council directly appointed by him.
No, we are not on the council in the court proceeding. We are not in the court proceeding. The chairman has taken a certain decision conveyed to the higher authority. Are you disowning those decisions?
No, we
You
not-
as the institute,
the
are you
institute doesn't
disowning
disown.
the,
No, we don't disown that institute. lordship.
no. Are you disowning the communications, the decisions made by the chairman? Are you making an argument that the decisions which were taken by the chairman were his own decisions, personal decisions, not the decision of the IIT?
IIT Guwahati represented by registrar has got no role to play, lordship. The
Who
decision of
can
the chairman,
do, in that
every-
case, we'll record it.
Lordship,
That you are not owning responsibility for any decision made by the chair.
lordship, that's my submission. That's my submission. Lordship. Obliged. That's my
Yes, sir, but that's-
become.
I like to clarify for your lordship, my lord. Hotel application received for regular appointment of director IIT Guwahati is 53, my.
you're a CTC
Yes, ma'am.
for
1, 2, and 6.
or one.
My lord, only one information I have got in the morning. My lord, total application received for regular appointment of director IIT Guwahati is 53 and shortlisted applications are 11.
Total applications are 11,
11 shortlisted.
not 300.
No, that should I clarify for short.
No.
In the morning, I have got
Total number of the
53.
53.
All
And shortlisted,
11, my lord.
total applications received,
50. My lord,
shortlisted 11.
I can to the notice of the court, the permission of court.
No, in this 11 shortlisted candidates,
My lord, if court asked me to provide that in.
yes, just want to have a look, that will have a bearing in our decision. We would not like to go for an academic discussion. If you are going ahead with the selection on a regular basis.
Yes.
Wherein the respondent number 5 may not even figure, then probably will not answer.
Yes.
The second part, Mr. Goswami, it's not be necessary. If in the shortlisted candidate, the private respondent he doesn't name, his name doesn't figure, then will not answer the second part.
Yes, my lord, anybody from the, this IIT Guwahati, whether comes within the short.
No, we are only concerned your grievance against the private respondent, Mr. Iyer.
IR.
If Mr. Iyer's name is not there in the shortlisted candidate, then will not answer the question. It may not be because your allegation of bias will remain only when Iyer would be one of the candidates who has been thought to be favored by the.
So it is, and the bias is twofold, you know, one in favor of IR, and the other bias is against the other 58. Because,
No, that part is.
no, I'm only saying the totality.
In a total, you are correct. You are correct. But in the records which have been placed before us, we did not find even a single sentence against you as such. Somebody was trying to favor Mr. Iyer. That is
That
apparent.
is
from the
one
report.
part, but
But not, he hasn't said anything that this candidate is bad or that is bad. He was trying to say that he is good. So if
he
I,
is good, plus in the third email, he has said, I have reviewed all, they are not fit.
he
That
finds
is where the
he finds
problem
Iyer
lies.
to be energetic, younger. So
Well, that
Iyer
is-
is not there. Can you get into at 2 o'clock? Mr. Bhattacharya?
Hello?
At 2 o'clock,
And the
just get the names of the shortlisted candidates.
shortlisted
It
candidate.
can be in a seal cover.
Yes, seal cover, I
Get
can
a
bring
seal
my
cover.
lord. Next week, my lord, maybe.
No.
Today is also a meeting fixed, my lord.
No,
They are busy with the meeting, my lord.
no, he can get the names from others.
If not at 2 o'clock, then today or tomorrow, day after, I'm not there.
No, today you should give the name.
I will try, my lord. But
We
today,
can
is-
fix it tomorrow at 2 o'clock.
yes, my lord, the meeting
You
is
get
fixed.
24 hours.
Yes, ma'am.
You get it in a seal cover
Seal cover,
and place it for them.
my lord. My lord.
We will actually have to look at the 13 numbers of candidates.
11:30.
So the idea of 300 application is not correct.
Not correct, ma'am. Today morning I have received this. Ma'am.
53 applications received, 11 was
Shortlisted.
shortlisted. We want to know the names of the shortlisted candidates.
Shortlisted. candidate.
On a confidential, in a seal cover.
Confidential, ma'am.
Yeah.
Confidential.
I think that they must right. Third,
Third.
in continuation of the RP, RP, that is senior counsel for the respondent number 7.
First part that replied.
Now we look at it, but none has come for this court. Nobody is aggrieved. We are not saying that petitioner has to be accommodated. We want a fair consideration for all the eligible persons. That's our lookout.
That's the whole, because we
We
have
cannot
said,
say whether he'll be appointed or he'll be appointed. We want that everything has to be done in a fair and transparent manner. That is our.
Yes,
correct, Milord, and we have said in page 13, the entire purpose is, Milord, that you are departing from a rule prescribed for all the IITs and which is going on for the last 50 years. And this is
No,
a
no,
precedent
we
which
have
should
taken
not
note.
be
We have
allowed. Whatever the result, your lordship's declaration is needed that what was done is not in accordance with law.
We, the pages of this
We gave it
photocopy.
I'm told,
given copies of these.
no, this meet,
This meet also we have given. We have given.
Right.
Yesterday we had given.
If it is missing, we'll give it again. Okay, okay. No, And
If it
the
is not there,
statute
we'll
we
give
need,
it
it
again.
is not, this is I think your book. You can just give the photocopy of the relevant page. Mr. Kakut, you can just help him, whatever you have referred. Regarding? No, you have to, you are supposed to give a copy. Yes. You have to,
Tomorrow, my lord.
tomorrow at 2. In continuation of submission, comma, are senior counsel. For the response number 7 has referred Institute of Technology Act 91 and the statute of the IIT. He has also made it clear that IIT Mohan, represented by the registrar, has no role in the decision taken by the chairman. That he, and has concluded submission. The PS Bhattacharya appearing for the responsible
1.6.
1.6 has submitted that as per instructions received this morning, comma, in the ongoing process of selection for the post of director on regular basis, comma, 53 applications were received, out of which 11 numbers of applicants have been sought. That considering nature of present challenge, comma, should be this court is of the opinion that if the list of short can be based on record, which may be done in a sealed copy. That to facilitate the Bhattacharya, two dossier message John and his direct listed tomorrow, we called up at 2 p.m. This record.
May it please your lordship.
Yes.
His lordship,
I have received a report, I have not gone through it, my lord. Day after tomorrow, my lord, I will read it, my lord.
Can I have it at 2 o'clock?
At 2 o'clock, my lord,
If it is possible, otherwise we'll accommodate you. These are old man.
that's why, my lord, day after tomorrow.
It is not possible.
I have to go through it, my
You will have it after 2.
lord, day after tomorrow.
If we have done it, I'm going to submit that record have just been traced out and according to trace for some correct consider that the get was applied for direct on
Day after tomorrow, my lord.
What?
28.
matter may be remain in the top of the list.
No problem. Keep the upload.
item 3. There's an interim order. Yes, this is Madam Sharma. The old selection of the year 2011. And there is an order to keep 20 seats vacant. Now the matter was not fixed since 2015.
Possibly the earlier set of councils was there, Lord.
No, there is a new, there's a, that we have noticed,
Yes, sir.
but there is also an interim order to keep 20 posts vacant.
Petitioners are not here, Lord.
The vacancy of the interim order, to take instructions whether those have been filled up by, couldn't have been filled up. But what has happened thereof?
Lordship, that I am without the brief also, Lordship. So I have to obtain instructions,
We'll have it day after tomorrow.
Lordship.
Give a chance if they're hearing. It's not to go. Are they there in court practicing? It's not there.
Lady, one lady is there.
Christina. And appears for whereas matter is updated dated. Matter is dated on first of
Fixing it on Thursday.
to have a look at this file.
Okay.
Right. And 3 matters. Here, yes,
The main thrust of the argument was, I'm giving the list of dates for that National Council of Teachers Education Act was notified on 1/7/1995.
yes,
The main thrust of the argument of my senior counsel was that the institution wherefrom the petitioner has completed a BA degree was not an existing institution.
correct.
That was the thrust of the argument. And as per section 14, may I take a look to the section 14 again?
Oh,
Section 14 of the National Council of Teachers Education Act 1993. So another copy has been given by James. In compilation, they have given to the I have not given the act. They have here in their compilation, the act is there.
I think that that this compilation. This one.
Yes.
Yes,
Section 14, look,
1/4.
1/4.
Recognition.
Recognition of institution offering course or training in teachers education.
Yes.
Every institution offering intending to offer a course or training in teachers education on or after appointed day may, for grant of recognition, and make an application to the regional committee concerned in such form, in such manner as may be determined by the regulation. That is very important.
Yes.
In such form, in such manner as may be determined by the regulation. Now I'll take you to the list of dates. Lordship will find the NCT regulation was notified on 24/2/96. I have given the list of dates. NCT regulation was notified in the Gazette on 24/2/1996. 24/2/1996.
Notified.
Okay. NC2 rules notified on 03/12/1997.
Rules.
Rule. Under the provision, the application has to be filed and the procedure for giving recognition. 03/12/1997. Now, Lordship, the institution where from the petitioner has qualified and passed the BA degree, he completed in 1996 and passed the BA degree. I have annexed the
Not petition, your applicant.
applicant. Lordship, he has completed his BA degree in 1997, June 1997. June 1997.
Your response number 7.
Lordship.
No. Who is your response number? Your response number
7. Lordship.
R7.
Okay.
What's your name?
Mokhruddin.
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 June 97 you obtained BS.
I have obtained June 1997. I have obtained the BA degree.
Okay.
So before rule has been framed, I have obtained the BA.
Yes.
Besides this, Lordship, the date of application as per rule section 14, 6 months from the appointed date. Appointed day also I have not 17/8/1995. Appointed day
Yes.
as per the section Section 2A. Appointed day means the date of establishment of National Council of Teachers Education under subsection 1, section 3.
2A.
2A. National appointed day means the date of establishment of National Council of Teachers Education under the subsection 1, section 3.
Yes.
Lordship, I have given it again to the list of dates, Lordship. The regional committees where application had to be filed. 4 regional committee was gazetted on 6/1/96.
Yes.
On 06/1/1996. And thereafter, the regional committee members and regional committee was established subsequently in 1996, where application have to be made.
Yes.
So, this case, Lordship, all these cases, for filing application, how they have interpreted, Lordship, for filing application to the regional committee was not there. Before the appointed day, regional committee was not there. Where application have to be filed. There was no rule and procedure where application have to be filed. I have given an institution of the whole of Assam. So you will find the institution which were established in Assam, and that were Lordship the institution. None of the institution, including the Lordship the basic training college in Guwahati state of Assam.
Yes.
At page 14, I have given the list.
page 14, I have given the list, Lordship. The institution of Assam, where they were given recognition. 1/4. From starting 1, Lordship, date of order 97-98, from date station 97-98 onwards, institution that Lordship the given recognition. Even Lordship the B.Ed college, that is Lordship the government B.Ed college at Guwahati, that is also notified in 1999. Whole list I have annexed, where it is regional committee, Assam, in case of Assam, were notified and recognized by the regional committee of national council. So my submission will be, Lordship, there is no question of recognition in 1996 when petitioner has completed his B.Ed course from Hailakandi B.Ed college. There is no question of giving any recognition by that. So the existing institution, the Assam University, was asked by the National Council of Teachers Education that before that, Lordship, kindly see page 1 when the National Council of Teachers Education were notified. Okay, list of dates again. 1795.
Yes.
Now look at second page. National Council of Teachers Education, that is the 4 regional committee, was notified on 6/1/96.
Correct.
Page 2. 6/1/96. That is a guest notification regarding constitutional regional committee. Now look at the rules. Page 4. Rule has been notified on 3rd day of December 1997. The procedure, everything has been laid down in rules, how to make the application and what will be the fees for application. Everything has been notified in the rule. That has been notified on 3rd December 1997. Page 4, Lordship. Here, Lordship, I will take a look at page 8. The letter from the National Council of Teachers Education to the Registrar of Assam University. I am drawing your kind attention to the fact that according to provision contained in section 14 of NCT Act, every institution offering course or training on teachers education before appointed day, 17 August 1995, has to apply for recognition to the concerned regional committee of NCT within a period of 6 months from the date. The provisions of the state are applicable to all colleges and Department of Education in all the universities offering B.Ed and other teachers education course. It is mandatory for teachers training institutions to obtain recognition from NCT. Due to lack of information about the procedure, many of the college and Department of Education did not apply for recognition within stipulated time. Procedure and norms and standard of recognition have already been notified in the Gazette of India by Council. In order to provide space to opportunities non-applying colleges and Department of Education, last date of receipt of application by the co-regional committee of the Council has been extended up to 18 August 1997. Thereafter up to 1999. And the Assam University College, where from petitioner has passed the B.Ed course, was established on 31/12/95. There is no dispute to that effect, because that day the SCRT Guwahati has given the recognition first day. Though institution was established prior to that, Constitution Institute was established as recognition from SCRT on 31/12/1995. 1995.
Here,
Lordship, SCRT.
give recognition.
Recognition. If that is considered as a date of establishment. And Assam University giving permission to the college school on 05/07/1996.
Right?
05/07/1996.
Assam University give for
Assam University giving recognition to the college affiliation. 057-1996. And applied for NCT for recognition within time on 12/8/1997. Before the last date. So, Lordship, in this particular case, I will take your Lordship to the I where I have annexed the judgment passed by the single bench of this honorable court, where the person who has passed from the same college, from the same institution in the same year, has been held to be valid.
IA.
Lordship. IA Miss Case 1185. Lordship will find the order at page 21. Lordship. Page 21, Annex 3, Lordship. Here, Lordship, respondent number 7, Gobindo Chakraborty. Respondent number 7,
Yes.
Gobindo Chakraborty. He has passed from the same institution in the same year. Now I'll take a look to the relevant portion. Page 28. Page 28. Middle portion. Does the submission of the petitioner Lordship, same counsel was appearing for this petition. Page 28. Does that has been submitted at Silchar College of Education, Silchar, which had applied for recognition on 26/3/2022. It could not have validly continued the courses after 6 months from the appointed date, that is 017/1995, date of degree conferred by the State Silchar College of Education in respect of the course conducted 01/01/1996 till 11/8/2003, date when recognition was granted was invalid. BA degree of the respondent number 7 and 8 were assailed on the ground that he had acquired degree from Socifusion Institute of BA degree in 2001-2002 prior to obtaining of NCT, and they had obtained their BA degree while serving as a subject teacher of Judicial Saha High School, Bihara, Kalin, without obtaining prior approval from the school where they were serving, and that as the distance between the two colleges they have tendered. These are the submission.
Yes.
Now I'll take a look at the page 44. Page 44 of the judgment. IL. 34. Moreover, the petitioner has only assailed the BA degree of respondent number 6 to 8 invalid. Nonetheless, although respondent 5-6 has appeared that NCT had granted extension of time, application to be filed for recognition up to 18/8/97. I had communication dated 29/7/1997, Annex 30 of the affidavit of opposition filed by respondent number 5. Said communication has not been assailed. The extension of date has not been assailed. Here also, that notification by the extension has been given was not assailed anywhere. Moreover, in absence of any challenge to the decision taken by the Executive Committee of NCT in its second meeting held on 7/10/97 to extend the date of making application for recognition, court is unable to hold that the decision of NCT to extend the date for making application for recognition till 18/8/97, which can be presumed to be a sort of post facto approval, cannot be said to be not in accordance with law.
Once such communication dated 29/7/97 was made to the Assam University for circulation among the concerned college, it would mean that the period of 6 months provided in provision of section 14(1) and 6 should extended till 18/8/1997. Now look at para 38, page 46. The finding. Thus, the point for determination is answered in negative and against the petitioner in WBC case number 1 by holding that B.Ed degree of respondent number 6, 7, and 8 is not liable to be declared as invalid, as the institution conferring such degree are found to be approval, recognition from National Council of Research Education.
38.
Lordship. Hereafter, against that order, the writ petitioner has filed writ appeal before this honorable court, division bench of this honorable court, and division bench affirm result.
Judgment is dated 28/4.
Lordship, judgment dated
28/4/2023.
date of order is 5/4/2022.
No, not single bench.
Writ appeal.
No,
Writ appeal
single bench.
date is 28 April 2023.
Okay.
Now, this judgment ultimately page 56. Before that, Lordship.
Page?
Page 55.
5.
Page 55. Relevant portion. Honorable Supreme Court in case Iman, reported in Iman, observed that many provisions of NCT Act could not be put into operation only after relevant provision of or forms came to be prescribed in the rule and regulations. In the absence of
You are
rule,
reading paragraph 8.
paragraph number 8. In absence of rules, the Act cannot be enforced. As the NCT regulation were notified on 3/12/1997, it would not be possible for colleges to apply for recognition during this period, which was thereafter extended from time to time. Be that it may, students who had commenced the B.Ed degree course from Silchar College of intervening period definitely be protected by extension letter 29/7/97 and 10/7/97. Learned single judge, after interpreting the factual legal issue involved in the matter, has dismissed the writ petition. In our view, impugn order does not suffer from any infirmities warranting interference. Hence, writ appeal fails and dismissed as being devoid of many merit. So my submission will be the Act, National Council of Research Education Act, though it came into existence, it cannot be enforced without having the rules and regulations, the procedure for filing application. Though my learned counsel has rightly argued the case, but factual metrics of the case is that though NCT Act was notified in the Gazette, rules and regulations were not framed, no institution could apply for recognition. That is why that has been extended from time to time. And Honorable Supreme Court has categorically held that without framing rules, the Act cannot be enforced. I'll place the judgment. I'll place the judgment. Okay, I will take the. I've given a compilation of the judgment. Okay. Lordship will kindly see page 1. That is a because this matter regarding the controversy, whether Act can be applied or not, I have touched out in different judgment of different high court and finally found that that matter has been finally decided by Division Bench of Allahabad High Court. And single bench judgment of the Allahabad High Court was challenged before the Division Bench. Division Bench says that if that happens, the whole system will fall to the ground. I will take your lordship to the judgment. Sampurna Sanskrit University, page 1. Page 12. Page 12, para 17. That is a single bench judgment of Allahabad High Court. Hereafter, I will paste the division bench. NCT Act 1993, para 17. Visualize that it will take some time to establishment of the Council for Regional Committee and to prepare guidelines under Section 32 of the Act. At the same time, it was found necessary to enforce provision of the Act expeditiously, and thus the institution offering a course or training in teachers' education were provided an opportunity to make application for recognition, to apply for recognition within 6 months of the date of establishment of the regional committee, to be continue with the course until the disposal of the application. The word before appointed day under provision of Section 14(1) refers to a course or training on teachers' education offered the institution before that date. It is defined in under Section 2A to mean the date of establishment of National Council of Teachers' Education, that is 17/8/95. The institution were required to make application to the regional committee, which were constituted on 3/11/1995. Very important. 3/11/1995 and notified on 6/1/96. Where application have to be filed was notified on 6/1/1996. The constitution and notification of the regional committee was within 6 months of the date of establishment of the council. It is relevant to note that the academic session ordinarily begins in July and continue up to April, May in the next year. Council was established on 17/8/1995. Regional committee was established with effect from 3/11/1995. Rajiv Joshi, appearing for the council as such, rightly states that those institutions which were offering teachers training course were entitled to continue with the course for academic session 95/96. They, however, could not continue with the course in the next academic session if they have applied for recognition to the regional committee, which were fully constituted, were functional from 6/1/96. Unless the affiliated college were fully aware of the provision of the Act, in as much as the university has made an application for recognition on 15/5/97 within 6 months from date of establishment of the regional committee. Now interpretation is there, Kotip. National Council of Teachers, establishment of National Council of Teachers Education, 6 months. Court has interpreted from the date of establishment of the regional committee, where application have to be filed. The affiliated college would therefore have pursued their course only after that application and thereafter until disposal of their application. Para 18, I find that these affiliated colleges did not make any application within the period prescribed by the provision of Section 40 and 1993, and further, these affiliated colleges, which have their own management, have not approached this court for seeking relief either for themselves or the students. These institutions were clearly informed by the NRC and CT Jaipur, not admitted any students in the year 96, 97, 98, 98, 99. These institutions did not care to respond to the degree offered by them the academic session 96, 97, 97, 97, 98, 99 cannot be treated to be recognized. However, was not restrained informed not to admit any student for 96, 97. Students who had applied for Shiksha Saraswati, the course from Faculty of Education, Varanasi, for academic session 96 and therefore were entitled to continue with the course, and their degree were not recognized by the regional committee, had not notified rejection of the application of 96, 97. Now, para 21, the court cannot issue a writ of mandamus responded to act contrary to the provision of NCT Act. The violation of the law, its stand must be objected by all concerned. The act cannot be enforced as he has submitted without notification amending act, that cannot be held. That judgment has been challenged in page 16, the division bench Ekta Shukla. Lot of judgment of single bench has been challenged. Page 16, look. This is division bench judgment of the Allahabad High Court. Page 20 is the relevant question.
Yes.
Last question. It will seem therefore that the application for recognition had been made to the regional committee. Page 20, look. 20. Relevant question.
Yes.
Last paragraph. It will be seen therefore that the application for recognition had to be made to the regional committee mentioned therein on the basis of appointed a period of 6 months would run the application would to be made by month of February 1996. However, council had not even nominated the members of the regional committee by that date. And regional committee came to be formed 2 months later than the last date of April 1996. If the strict period of 6 months for the outer limit for making application for recognition to be given effect now, none to continue the institution would be eligible to grant BEd degree. That would be an absurd state of affairs. What happened was the last date of making application for recognition was extended by an executive notification made by the council, and first such date was extended till August 1997. Again, here was another extension. This time, a late in the year 1999, by second extension, last date was fixed on 31/3/1997. So it happens, the Department of Education and University made application for recognition on the 24th May 1997. These are not relevant, Lordship. Now, Lordship, the last but one, the basic finding of a Lordship, which has gone against the appellant as follows. Lordship, got it? Middle portion, Lordship. The basic finding of his Lordship, the single bench finding.
Yes.
The basic finding of the Lordship, which has gone against the appellant, is as follows. The degree, however, for academic session 96-97, pursued in the affiliated college of the university for the year 97-98, 98-99, both the faculty of education by the University of Affiliated College is not valid, as the university and college were not recognized for the academic session. This qualification shall not be treated as to be valid for purpose of pursuing special BTC course 2004 and public employment. Some submissions were attempted to be made before us that the extension of last date by National Council first up to August 97, then again up to March 1999 is invalid. This submission has got to be rejected, as otherwise all recognitions BEd course in all colleges would fall to the ground. Now, last portion. Look. It is, the appeal is therefore allowed. The order under appeal is set aside. It is last portion, page 22. It is declared that the degree for academic session 96, 97, 97, 98, 98, 99, and indeed all academic year pursued either in the faculty of education of the university or in any affiliated college in question is valid, and that the qualification granted by all bodies shall be treated to be valid and for the purpose of pursuing special BTC course either in year 2004 or any other year of public employment. So division bands, earlier lots of single bands has stayed 96, 95, 96. Now division bands of the Allahabad High Court has stayed up to 99. Lordship, thereafter, Lordship, I have same judgment was, same course was challenged. Page 24, I have obtained a certified copy from Allahabad High Court. This is also division bench judgment. From page 41 onward, it is the judgment has been started. Look. Page 47 is the relevant portion, para 6. Page 47.
Yes.
From para 44, 45 to better to para 9.
Paragraph 9.
Paragraph 9.
Again, there is.
So the application for grant of recognition. Page 45. Page 45.
Paragraph 9.
Okay. The application for grant of recognition in terms of section 14(1) has to be moved before the regional committee concerned in such form in manner as may be determined by the regulation. National Council of Teachers Education amended validation ordinance 2006 have been promulgated, whereby application could be submitted for grant of recognition ex facto also. The central government has also framed rules known as National Council of Teachers Education procedure for recognition of certain categories of institution rules 2006. These rules prescribe the manner in which the application is to be made. The time limit has also prescribed for making application the rule. A notification has been issued by NCT on 31/3/1999, whereby the last date of making application for grant of recognition has been
These
extended.
are all treated.
Same fact, ultimately held that the up to 99 it has been held to be valid by division. Now, Lordship, I will take your Lordship to the Supreme Court judgment, page 50, Lord. 50. Lordship. Citation is Air Supreme Court 1395, 1995. 1995 Air Supreme Court 139. Or 95 Supplement to SCC 348. Yes. Last question. Page 56. Last question. Look. Once it is found that last but third sentence. Once it is found that
Paragraph
paragraph 21. Once it is found that on a proper construction of act and rules do not apply to professional and technical education institutions, then note that provision of rules, including Rule 11, can be said to apply to professional and technical education institutions, and it is not possible to say that some provision of the rules are applicable when do not apply to the such institution. If reason aforesaid, we do not find any merit, these appeals and same are accordingly dismissed. It has been stated in this judgment that without framing the rules, act cannot be applied. Supreme Court has said, rejected, and Supreme Court has ultimately held. I'll give the remaining paragraph also. Before that was page 56. Page 56 again.
Yes.
Middle portion.
paragraph.
Paragraph number 20. Moreover, acts and rules form part of a composite scheme. Many of the provisions of the act cannot be put into operation only after relevant provision or form is prescribed in the rules. In absence of rule, act cannot be enforced. That is relevant. So in this particular case also, the rules were not framed, regional committee were not constituted when petitioner has pursued the B.Ed course. So from where petitioner has passed the B.Ed course is expecto legal. The Supreme Court has been laid down in next judgment in para 22 next judgment that is reported in AR 2011 Supreme Court page 63 para 22. Logic will find Bhupendranath Tripathi, State of EP versus Bhupendranath Tripathi. Para 22.
It is compiled.
Lordship.
Compiled.
No. Before that, there's judgment is there. there may be mistake. State of UP versus Upendranath Tripathi. 2011 AIR Supreme Court page 60. The judgment is there. Look. Let me compile.
Asilikam and that
Upendranath, state of BP versus Upendranath Tripathi. If I'm slow reading, I'm heading with the people. Somehow it is because of mistake. Look, 2008, 2011, Supreme Court, page 63. Or 2010, 13 SEC, 203. Name Lotip, state of UP and others versus Bhupendranath Tripathi and others. Bhupendranath Tripathi and others. Para 22. Look. Para 22.
report doesn't do your report. Something was done, you did without your. Do you want to do that? Something is agreed up with the, at least on those parts, first part of the. But do it take going to sign this.
Okay, para may be different because
Doesn't matter.
in our considered view, last part, the paragraph, last part 2. In our considered view, in our considered view, state government cannot make a distinction between the degree obtained from existing institutions prior to the act coming into force, but receive recognition after commencement of the act, and degree obtained from the recognized institution after the act coming into force. It is known that such a classification is based on intelligent differentia, not on rational consideration, and further how it bears a nexus to be purpose to an object. Therefore, the impugn action of the state results in the classification of division of members for homogeneous group and subject to them different treatment without any rhyme and reason. Learned senior class in appearing state, however, submitted that the state which runs training course for NCT is entitled to prescribe the qualification. Candidates seeking admission to the course, so long as qualifications prescribed are not lower than those prescribed by or under NCT Act. The submission was under NCT Act as came into force. The state is justified insisting prescribed BEd qualification only from such those institutions recognized by the institute. Reliance has been placed on Iman. There is no quarrel with the provision that the state is the discretion is entitled to prescribe such qualification as may be considered appropriate for candidates seeking admission into BTC course, so long as the qualifications to prescribe are not lower than those prescribed by the NCT Act. State can always prescribe higher qualification, but the argument proceeds to the assumption that the BEd qualification obtained from any such of those institutions established and recognized by NCT after the Act came into force is higher or superior than the BEd qualification obtained from the universities or affiliated college. duly recognized by University Grant Commission prior to the act coming into force. What is the rational basis for such presumption? None. This act assumes significance, particularly in the light of the fact that all institutions from where the candidate obtained B.Ed qualification have themselves received recognition from the regional council after NCT Act came into force. So, in this particular case also, the Assam University has given the recognition. Degree has been conferred by the Assam University Silchar. So, my submission.
Yes.
So there cannot be any distinction because our degree has been conferred by Assam University. And later, whereby Assam University was informed for making application, NCT was aware that there are 5 institutions under Assam University. They have asked to apply for recognition within specific time. In the letter, they have not informed the Assam University not to close the institution, not to continue the course. There is no, in the letter, you will find, there is nothing in the letter to close the institution. In fact, I'll read one letter where the Assam University has written to the National Council of, this is a letter of the National Council of Research Education to the Director of College of Development Council.
Which page?
I'll give the letter. That letter is not there. I'm reading, I'm giving copy. That is a letter dated 6/8/97 by the regional Eastern Regional Committee. Dated 6/8/97. With reference to your letter on subject mentioned above, I am to say that Difu B.Ed College, Hailakandi B.Ed College have not applied to this office for recognition. Since we do not have the complete address of those colleges, may I request you to advise them to submit their application for recognition complete in all respects by 18/8/97, which is the last date of receipt of the application in this office. Information which may be given regarding permitted college under your university is very much useful for consideration of this application. As requested, this office letter number Iman, we require some more information in this regard. Please furnish the same and let us know if the students appearing in the from permitted college or college to candidate. So, by letter of the regional committee, they have not informed the regional committee that this institution should be closed immediately. Students should not be admitted. They have been allowed. In fact, they have been permitted to make application by giving last date, specific date. And Assam University also informed the regional committee that these are existing institutions. This is letter from Assam University. Dated 26/5/97. With reference to your letter that I have to honor the furnish below information as asked for. Hailakandi B.Ed College. These are not part. I am to show only that NCT has not given any letter that this college should not admit any student without applying for recognition on the last date before last. The last date has been given for making application. I will give a copy. And it has been stated these are the existing issues. So this is my submission. And regarding one stand has been taken on earlier occasion or last occasion, it was not submitted, but it was submitted that contrary affidavit has been filed by National Council of Research Education in earlier pending cases. That also discussed by the Honorable Singh Judge, and apology has been asked by National Council of Research Education because file was not located. I will take your to the same paragraph, Lordship, at page 24 of the IA, Lordship. Page 24. Judgment, Lordship. Regarding contrary affidavit, Lordship. Page 45. 45. F. Paragraph 35. It is not disputed that a contradictory affidavit 10 of NCT was taken in their affidavit filed in proceeding Iman and Iman, in the proceeding writ appeal number Iman. In the said proceeding, NCT stand was to the effect that BA degree granted by Silchar College of Education prior to 2002 was invalid. In this case, NCT has given an explanation that on 11/5/2001, after NCT has refused to grant recognition to the state college, the concerned file was closed. Thus, the degree obtained by the student till year 2001 was valid. It was further explained that after Silchar College of Education applied again for recognition, said application was taken up by different file bearing number Iman. After finding the requisite compliance of the all deficiencies, recognition was granted for the session 2003-2004, and that for all the purpose, the College of Silchar College of Education was considered as a new recognition, and all subsequent record to be maintained in the said file number. It was stated that previous file was not considered by NCT while submitting their affidavit in opposition, for which NCC tendered unconditional apology. The court is unable to wholly discard said explanation is unbelievable because of the maxim. Thus, under the peculiar facts and circumstances of the case, court is inclined to accept the contention of NCT, and therefore this present case is held to be acceptable. However, the court has to add that no comment is being made on the affidavit position filed by NCT in the previous proceeding, nor in the opinion whatever expressed in respect of the judgment Iman. Present decision is rendered to our presentation of respondent number 6, 7, and 8. So the contrary affidavit has also been explained.
Now you have said that respondent number 7 in here
is same institution, same year, same thing. From Hailakandi BEd College. That is paragraph 38
7 has been
held. And that has been affirmed by the division. And now also NCT has said by filing affidavit that it has expanded the time for filing application up to 1997. So it was in Allahabad College up to 1999. Here also they have admitted up to 1997 they have extended the application for filing. And look, the nowhere in any one petition this extension order was not challenged. No one has challenged the order of extension given by the NCT. So this is submission of the degree conferred, and petitioner in the selection process, petitioner stood fast. In the selection process, petitioner stood fast in the selection process. Applicant. In the I applicant.
that is only on the ground of yes.
Yes.
Otherwise, not married.
No.
You have secured more marks.
No marks.
But your beard goes, your beard says you're on a better.
And look at the basically the petitioner has challenged the intercommunication between the director to the by the government to the director, holding that the degree of the petitioner is valid. That is understood. Intercommunication. That is dated 22nd June 2020. That is a letter by the government to the director. 22/6/2020. Obliged.
Will do one thing, will hear you after. You have filed your affidavit. Five double two one.
5221. Except 5 lordship, because 5 is from different college. So our affidavit lordship filed by the respondent number 6. Lord.
Need for
So
number.
respondent number 6, Lord. And 6. So here, lordship, although the petitioner had not sought any direct relief from the institute, but for declaration of the degrees, we stated the facts for your this honorable court. The facts of the case is that, lordship, for enactment of the NCT Act, lordship, when the NCT communicated with all the universities, because we have no knowledge about the existing colleges
Right.
under the university. So we communicated with all the universities. Accordingly, Assam University teacher was also communicated and informed that the NCT Act came into force and all the colleges under them required to file their lordship application for to getting recognition. Subsequently, lordship, Assam University wrote a letter because lordship, this is actually transition period. Although 17/8/1995 is the appointed date, as your lordship already here that rules came subsequently, regulation also came subsequently. So actually there is a transition period, lordship, and earlier also communication was not clear, lordship, because this is that nowadays, lordship, email communication is there, lordship. So for that purpose, lordship, the Assam University informed the NCT that they have 5 colleges under them, and 2 of them are permitted colleges. Permitted colleges. Permitted, lordship, there is a rules of the Assam University, lordship, that before granting affiliation, lordship, perhaps for 3 years, lordship, they grant permission, those colleges to run. Thereafter, final affiliation was. So that was informed to the NCT, lord, and subsequently, lordship, NCT communicated with the universities that they would require to file the recognition, and accordingly, date was extended time to time, because keeping in mind the problems, lordship, which faces by all the colleges due to non-information, lordship, and accordingly they applied within first extension within 18/8/1997. So subsequently, lordship, within 18/8/1997. 18/8/1997. There is the first extension was granted, lordship. So lordship, as the colleges already filed their affidavit, so now, lordship, the one question arises that whether that colleges was existing prior to the appointed day or not. That is the main question. But the fact of the case is that, lordship, because NCT is not in a position to say like whether that colleges was existing or not. So our contention is that, Lordship, admittedly they applied within because there is a transition period. If 17/8/97 would be counted as the appointed date, which are already notified, Lordship, but T12/97, Lordship, the rules were came in. So, Lordship, there is some gap, Lordship. So, although they have applied, so now, Lordship, the Assam University as well as the concerned college is in a better position to say that whether they are existing or not. That is another topic. And now the treatment of the NCT is that, Lordship. We earlier filed affidavit stating clearly that the degree obtained prior to the recognition of the NCT that are invalid. That was admitted because as per section 14, everything will be clear. But the earlier affidavit was filed, Lordship, before passing the judgment of this honorable court in division bench as well as the. So, Lordship, now we place only the record, the statement as per record before your Lordship, and your Lordship, in your Lordship wisdom, your Lordship may pass necessary order about the validity or non-validity of degrees. And moreover, Lordship, at page para 11 of our affidavit, Lordship, para 11, Lordship,
Of
our affidavit, Lordship, page 11, Lord. Sorry, page 96, Lord. Para 11. Here we stated the entire fact. May I read it, Lordship?
Yes.
The deponent begged to state that Assam University Silchar White letter dated 5/7/96 acquired permission to start the then Hailakandi B.Ed College for the session 96/97. And respondent number 7 is the first batch, perhaps, Lord. It was 96/97 first session. And White letter dated 22/8/96. The Assam University informed the NCT that there were 5 B.Ed colleges within the jurisdiction of the Assam University, which includes the Hailakandi B.Ed College, which has been offering the B.Ed degree, and assured the NCT that henceforth permission will not be granted for opening any B.Ed college without prior approval of the NCT, as required under the NCT Act. The NCT Act 1983 came into force with effect from 1/7/95. Under section 14 of the NCT Act, the institution offering a course or training in teacher education immediately before the appointed day shall be entitled to continue such course or training for a period of 6 months, which was extended up to 18/8/97. The deponent humbly begs to state that the NCT allowed the B.Ed degree obtained from the institution who have applied within 18/8/97 as a valid degree, which was accepted by this honor. So now, Lordship, we could not be in a position, Lordship, to say that whether valid or not, because already that was entertained by this. This is my sub.
Yes.
Obliged.
That's what
I appear in item number, Lordship, 6 and item number 8.
can he. That
Same case, Lordship, pertaining to the Lordship, if your Lordship kindly takes up item number 6. It has been. It has been.
you are the petition.
I am the petitioner.
What is your check?
Lordship, in this case, I have challenged the impugn order passed by the respondent number 1. What happened in this case?
What is the impugn order?
Impugn order, the respondent number 1 has held that my B.Ed degree is not valid. Obtained
Same
from the
college.
same call. Same call. And Lordship may kindly see page 18, annexure 3. Only the factual part will be different. Otherwise, Lordship, this case will cover my senior. Impugn order is 24/1/2020.
Name of your client,
Gita Das.
one
I have challenged the impugn order dated 24/1/2020.
1740.
1740/2020. Challenge the order passed by the respondent number 1 on 24/1/2020, page 61,
Mark,
2020.
the response number one, date.
Lordship, sorry, Lordship, page 61.
Now, who is the response number one?
Respondent number 1, Lordship, is the
State
Commissioner and
Department.
Secretary.
Department. But, and what has been done?
Uh, Lord- the last bottom paragraph. In respect of Lordship, there are earlier 3 rounds of litigation, Lordship, between the petitioner and one Lordship, private respondent who is no longer here, Lordship. His master degree was set aside by his honorable.
Press, earlier his, why this your BA degree has
Yes.
been filed.
It is text from the checklist furnished by the DS that he has obtained a BA degree in the year 1997 and Dr. SP Institute of Education at Hailakandi and the state teacher got recognition on 13/1/2000 and therefore in view of the invalid BA degree of Srimati Gita Sri Das, her case has not been considered for appointment to the post of principal of Swarnalakshmi High Secondary School. Lordship, prior to that, Lordship, my upon selection, Lordship, was approved by the state selection board, and when this matter was sent by the director before the state level, before the commissioner, government for approval, only at this stage, after filing of a contempt, Lordship, this order has been.
There is no private correspondence.
Now, Lordship, because the impeding petition has been. Lordship, may kindly see page 18.
Other arguments are adopted.
Yes, Lordship, yes. Annex 3, page 18, Lordship. 18. Lordship, this permission was granted to Lordship, along with Lordship Mofaruddin, Gita Sri Das, and Govindalal Chakraborty. And Govindalal Chakraborty, your Lordship has already seen in the division bench order. His PhD degree has been declared valid. The permission is also granted. All Govindalal Chakraborty's case, Lordship, has been allowed by the division. Lordship has already same bed, same meet.
Mofaruddin is
Mofaruddin is represented by Goswami, Lordship. Lordship, one last annexure, Lordship. Annexure 11, page 59. That is the approval.
Right.
Annexure 11, page 59. Lordship, after 3 rounds of litigation, Lordship, my name was finally approved, Lordship, by the State Selection Board, and Lordship, this was sent for approval. Government was requested to grant approval on the recommendation of the State Selection Board. My name was recommended by the State Selection Board. Lordship, may kindly see page 60. Lordship, in the remark column, Lordship. In the remark column, Lordship, the Vitasri Das is recommended for the post of principal of Swarnalakshmi Higher Secondary School as per Honorable Court order dated so and so, a speaking order issued, speaking order number so and so. Now, Lordship.
Yes.
This was issued in 2019. Because of the delay, I filed a contempt. Just to save from the contempt, Lordship, the Commissioner and Secretary have passed the impeachment order request. Now, Lordship, in this case, there is an interim order. Lordship, without leave of this court, no one can be appointed as a regular principal. And item number 8 is a Lordship instance arrangement law. That is a dispute between again the petitioner and the private respondent, which is represented by Mr. Soikia. So, if your Lordship decides item number 6 for a regular post, Lordship, then item number 8 will become infractor. Item 8 for only for temporary instance for the same post. WPC 1663 of 2020. That is it for temporary Lordship instance. If your Lordship decides the validity of the PhD degree of the petitioner in item number 6, then item number 8 will become infractor. Because that is a temporary for instance.
160.
Yes.
There are 2 issues in
What is
item
your
number
name? Your name is not written on it.
Lordship, I have filed an IA, that is Vitasri Das. In the meanwhile, Lordship, she was appointed as a temporary instance, then she was removed. I was again given the start. Then he filed a writ petition, Lordship, there is a stay. Now that is a matter of for instance basis. But this is a for regular. I have already been approved for regular appointment.
In item number 8, you are the petition.
Yes, my lord. There are 2 issues in item number 8, my lord. My medical leave has been rejected, and my lord, my service for the period of treatment, my lord, that has been they have shown some break in my service that has been challenged before your lordship, and along with my lord, the removal from internship, both are under challenge in item number 8.
That
So,
is
my
why,
lord, even if the petition is decided, item number 7, then also my lord, that petition will not be.
So will it make any difference
No.
if we decide in your favor?
But my lord, the period of service, my lord, which have been they are showing my lord absent, that your lordship is decided, my lord.
So what is your prayer here? The other,
Only
but so far as that covered.
Yes, that will be covered.
it will be covered. Item number 5, Lordship, is pertaining to Vivekananda College. Not similar with the
I put the petition.
Five.
Five.
Against that college, it is pending. But that may be.
Five or three.
Same issue. But college. But it is pending against that college. Same issue.
Then why is this
But I challenge the section of private sector here in my
in this case?
yes, prepared of private.
Not this. Not this. If your tenant has not trust, we will not then I don't know five. What is it? WP
I
one. So the name
Nazrul Islam.
you challenge the BA degree of
All the private then the basic
who was the private husband of the eight, not eight. 10. Eight then.
Eight.
10. So number 10 has started some interim. Our 10 has started. What is age? Age is the which year? 17. 5 years have enough. Who was appearing for response for 10? Any counsel? As the and her
that's not fair. But before my lord,
2015. But he has he has his yet we cannot talk. He has a fight. We cannot talk all. Is the issue same for
pending my lord, still at the
yes. will,
I may be permitted to give you the short reply.
have replied. One. I mean,
My lord, 5 minutes is enough.
they have, they pay one last.
Yes, yes.
And you said that this before paragraph 5 from submission is the insert.
Yes, my lord. My submission will be, my lord. I'll be very, very brief, my lord, 2-3 minutes. Firstly, my lord, your lordship will has now it has come to light. In item number 6, the person who has, my lord, passed out from the Dr. Srishti Bhushan Institute, his degree has been held by the government to be invalid. In item number,
Mr. Kedas,
yes, my lord.
Kedas,
And in my case, item number 7, the person who has passed out private respondent from the same institute, that degree has been held to be valid. And this is a case, my lord, where the government has not filed any affidavit. Therefore, my lord, the learned government advocate has to, my lord, take a stand, because 2 contradictory stands have been taken. And both the, my lord, private respondent here and the, my lord, petitioner there are from the same batch. Government has not filed any affidavit. Then, my lord, your lordship has already noted down the dates. The submission of my learned friend, Mr. Goswami, is that since there are no rules, they could not have applied. They did not say that because there were no rules framed, we could not apply. Mr. Goswami's case is that without the rules having been notified, the act cannot be enforced, and that it's not their case that they could not apply because the rules were and the formats were not there. They have applied on 12/8/1997. That is a very important date. If, my lord, you were prevented from applying because there were no rules framed, then why did you apply? So the case built up in the writ petition, and actually their case is different. So that date your lordship will kindly note, my lord.
yes, 12
Yes. Now, my learned friend has relied on certain decisions. Now, what, my lord, as I understand, what he did is that, my lord, he had taken some sentences or paragraph from one paragraph, from one judgment of the Honorable Supreme Court, which does not really deal with the issue. For instance, my lord, in 1995 to SSC 348, the Kashilingam case, that is a case relating to, my lord, application of the state of service rules. This does not relate to NCT. The issue there was whether the particular rule 11 of the service rules will govern their conditions or not, because the rules were notified subsequent, not relating to NCT. Therefore, my lord, the submission that without framing the rules, act cannot be applied, my lord, these are not, my lord, supported by the judge, my lord.
cannot be universal.
My lord.
Cannot be universal.
True, my lord. And my lord, what is the issue?
Which on its own are operating. There are many acts.
Yes.
Without there being rules, their acts are operating.
Yes, my lord, and the regulations were
Where
there.
only some format, something are mentioned in the act, that be done. Same.
Yes.
In those cases, without the rules for it, the act not coming.
But the fact remains that you have applied already. Before that, you have given degree to the private respondent. And your lordship will kindly take note of the, my lord, what is the issue before your lordship? Whatever the decisions pertaining to NCT, and my lord, the decision relied on by the NCT or concerned, NCT's affidavit is vague, my lord. They do not clearly take this stand. Those are, my lord.
Mr. Barbia, can just have a measure put
It will, my lord, it will.
because it is there whose decision,
True, my lord. But at the
and they
same
are
time,
saying that we'll go by what the
true, my lord. But then the issue is regarding, my lord, the existence of a particular institute on the crucial date. Whatever has been stated, these are all regarding the existing institute. Therefore, my lord, there are two classes apart: existing institutions and the institutions who came subsequently. So that calls for my lord, consideration before.
will be the judgment is 55-1.
My lord. 5221 is my case. My lord, item number 7.
And but the Pallister is correct? The
Yes.
Pallister
Yes.
and the others has data stage will be covered by one and data run and
That is
also
only for lordship,
come with
for temporary.
and I put there are other two issues.
One submission may I make?
We have
Current is there is interim order operating. Now, honorable court has
Regarding the decision, my
inspector of school to hold the search.
but my
So
friend has
that order be interfered with, otherwise the principal also allows, I will not be allowed to hold the post of. Or in item number of the, so there's an interim order allowing the inspector of to hold it. Now it will also, that's the whole.
the date?
Item number 8.
date your
Yes.
that will be decided in the case of Ritarani case. Because my lord, Ritarani case
Now,
will
will then
lost.
verify.
we have
That
it told there yet people
One
what's the date?
is
last judgment, my friend has deferred. Can I make a small submission on that? My fingerprint was not there, my lord. 2010 13 STC 203, my lord. 10 13 STC 203, my lord. Yes, my lord. That is, my lord, paragraph 35 was relied on, my lord, my friend, my lord. There is no quarrel with the proposition that the state in its discretion is entitled to prescribe such qualification as it may consider appropriate for candidates seeking admission into BTC course, so long as the qualification to prescribe are not lower than those prescribed by or under the NCT Act. The state can always prescribe higher qualification, but the argument needs process on the assumption that BA qualification obtained from only such of those institutions established and recognized by NCT after the act coming into force is higher or superior than the BEd qualification obtained from the universities or affiliated colleges duly recognized by the University Grants Commission. In this case, my lord, those institutions which were established after the cut-off date, my lord, that is, my lord, date of, my lord, cut-off date is 7/8/95, those were recognized by the NCT and they claim to be superior to the existing institutions which were not recognized. So, my lord, that case cannot be
Factor
taxable. My lord, that is my
those by
Yes.
those have to be given. That has been expressed.
Yes.
for state? Any
One line, the same is the other. If we have the first order, that was passed before Pranita Sharma's judgment. And the second order in Muthabari, we are upholding the degree has come after the Pranita Sharma's judgment, referring to Pranita Sharma's judgment. So it is not as if we are taking different stance, different time. Judgment comes from the honorable court, we act accordingly. Otherwise, my lord, the matter has been fleshed out with actually, I think.
What's the interim order passed in WPC? It is 23%. Twenty-three. 2023, and in terms of the High Court order lawsuit, the inspector of school has taken over 5-4.
will pass the
Highly obliged.
But issue involved is very narrow compass, my lord, whether petitioner will get that the retirement age has been already fixed by the state government. This, my lord, Lordship may take up a two or otherwise inconvenient.
can hear this matter.
My lord, yes, as from two, my lord.
We can hear this matter.
Yes, my
for
lord.
disposal.
Building is complete, my lord.
Yes, sir.
But issue, my lord, petitioner is a professor under Romeo Kumar Das Institute of Social Change.
Right.
My lord, he is in the subject of political science. Prior to joining this institute, he was working in Northwest North Bengal, my lord, in a university. Thereafter, my lord, he came to this institute. Subsequently, he was promoted as professor. But in the meantime, in the year 2012, the government of Assam has taken a cabinet decision pursuant to which the retirement age of professors has been increased to the age of 65 years. And on the basis of that cabinet decision, my lord, a notification was also issued increasing the age of retirement of the professors across the state to 65 years. But my lord, that benefit has been denied to the petitioner under this institute. That is the, my lord, basically the issue. And in fact, there are many resolutions taken by the institute itself, which has stated that it will be 65 years.
What is the reason for not
It is under
extending the benefit from your
in
commander?
the affidavit, my lord, they have taken the only stand is that the institute is not an educational institute, rather it's a research institute. And that is the only stand taken in the affidavit. And this is a case of, my lord, clear violation of Article 14, my lord, in my respectful submission, because
You don't impart education in Amrit.
we impart, my lord, this is there, well. But fundamentally, my lord, there cannot be any distinction between whether it's a research institute or an educational institute, because cabinet took the decision regarding enhancement of age of superannuation in respect of professors only, irrespective of, my lord, whether he's from a research institute or educational institute or whatever, my lord. And that is the only stand. In fact, my lord, this institute,
No, your job present was the job for professor.
yes, my lord, professor,
You are a research- You're a research guy.
yes, research guy, PhD, we confer PhD also from Dibrugarh University, my lord, affiliated to Dibrugarh University. And my lord, in fact, my lord, this is a co-funded by the state of Assam, government of Assam, and the ICSSR. There are 24 institutes all over the country which are funded by ICSSR. And in all the institutes, my lord, which are 100% funded by ICSSR, already age of superannuation is 65 years for professor. And those in respect of the institutes which are sponsored by the respective state government and ICSSR, the retirement age of the respective state universities are followed. That is, my lord, on there, my lord, on the record.
Yeah, but
That too,
is there any validation or
no, yes, the validation is there, my lord. There institution is not, my lord, like that, my lord, institution like a university or any
no,
other.
what the company has asked us that institutes of this nature which are funded by as well as the what age right for the university of with the age for
Yes, my lord.
the faculty members professor. That be the case. What is your
Our 10 is, my lord, here. We have calculated it, my lord. These institutions, my lord, actually, my lord, it is not under the, it is not fall under the government like that, my lord. The university and other colleges, university. In college also, professor is there at 2 p.m., my lord. Honorable Court, to place the, my lord, cabinet decision before this honorable court. So far, this is a judicial order, my lord. We have received the, my lord, we have communicated all these things, and they have sent it sent to the, my lord, State Council, Education Department, and they have to come back. And today also I received an instruction. They, my lord, praying for some time to produce it. So, if the order is, my lord, there, my lord, so whether what you will take up, my lord, your
This
no,
is
we,
the
we
third-
will produce it, my lord, because only because of that, yeah, yesterday was one of the holiday in the government.
Last three
today-
occasions, my lord, on the same ground, time has been sought. And additionally, my lord, all the
This
affidavits.
is
have
the
been
letter, my
filed.
lord, today we have received. In continuation of my earlier letter dated 23/9/2020, they are continuing writing, my lord. I am directed to inform you that there will be a delay in finishing the cabinet memorandum and the proposal placed before the cabinet regarding raising of the retirement age of the professor of education institute to 65 years, as the files are under process in respective department as per official procedure. Hence, I would like to request you kindly to seek an extension of time for arranging the appointments of documents to place before this honor. That is the, my lord, that is the practice matter, 1 week time may be, my lord, granted.
Otherwise, my lordship may take up some later. Or if your lordship considers that it is required, it may be placed at any point of time.
Without going through the cabinet decision also, we have not seen, my lord. I cannot commit anything.
is there a cabinet memorandum?
Cabinet memorandum, my lord. Raise the age of retirement age of 60 to
So where is
65.
the why don't you produce?
My lord, it is, my lord, 1 week, my lord, because it is
No, this order was passed on
August,
10th of
August.
10th
Within
of the
September.
matter has come thereafter. Okay. It's only a question of this cabinet memorandum. Not something to be done now, then
There is also no dispute that there was no cabinet. Actually, on the basis of that cabinet decision, age of superannuation has already been
That's why to
enhanced.
resolve the matter, my lord, lordship want to see the
there is an
cabinet.
order.
Yes, there is an order. In fact,
To
there was
resolve this
also
controversy.
an order. Lordship will see my Lordship order passed by my Lord Justice Suman Shyam. My Lord, that's the order dated 3rd of March, probably 1st of March, my Lord. Last part of the order may kindly be perused, my Lord.
This is a subsequent order, August 2000.
No, that was 15, but on why issue of having the cabinet memorandum days before
Delay,
the vote has arisen by.
So they have written through, Mala, they have communicated it to the higher education, and higher education, they
So
have
prior to this paragraph, it recorded that with her
Yes, yes, affidavit.
matter can be taken up.
Yes, my Lord.
affidavit has been filed.
Thereafter, Mr. Nath submits that government has not considered institutional education, but rather the research. To resolve the controversy, court to supported by, and if any possible proposal submitted and please put a place.
But the the argument taken by the here is that the enhancement of the age for that particular institute, the institute in question here, is lies with the government, because the ICSSR, they are having 24 institutes, similar institutes throughout this country, and it is the admitted position that in Assam the age is different, in Delhi the age is different, stuff like that. And the stand taken is that it is up to the state government, concerned state government. So here the question is that the state of Assam has taken a decision that the age will be 60. That is why Lordship has asked for the.
No, my Lord, issue is
No, what Mr. Chakraborty has submitted for the
No.
that in cases where both the state government and the body they are involved, it is the age which the state government prescribes for universities.
respective state university, my Lord. But
The
that
state
affidavit
university.
is also there, my Lord.
But here the state government has considered this particular institute is not the institute is not to be an educational institute. This is a research institute according to the government. Therefore, that enhancement of age 65 years is in respect of educational age.
Now, how do you differentiate between
No, that is
and an institute which is also imparting?
no research. They are not.
So we
they
are
not giving any.
undertaking PhD graduates, my Lord, taking regular courses
They
are
are
also
not.
there.
They are not giving any course, and they are doing research work, and that is why Lordship wanted to see the cabinet.
Petitioner is not doing research. He is acting as a guide for some scholars. So his job as a professor remains. Whether the students they are pursuing a scholar course or they do research for a PhD, cannot make a distinction. Which are can you make a differentiation?
In this case, Lord, I am appearing for the respondent number 4, 5, 6, and 7.
Who are
4 is the ICSSR, that is the Central Government Agency, and 5, 6, 7, 8 is the director and the Omyo Kumar Das Institute of the. So, Lord, what we have stated in our affidavit that this is the government. In fact, the proposal is given, but the government has turned the proposal and said that no, this is not an educational
so
institution.
main defense will be
Main-
by Mr.
Yes,
Kutia.
yes, Lord, the
Lord,
government.
the institute, my Lord, basically is funded by the state government as well as the ICSSR. Lordship, no, ICSSR is under the Ministry of Education, Government of India, where retirement age is of 65. So how they could have been at this,
No, I think there is not against.
they are also matlab, in the affidavit. They are saying
No,
that this
In their affidavit in reply, the
Lordship,
petition-
kindly take up for
petitioner-
a moment, my Lord. The affidavit in reply filed by the petitioner.
No, Mr. Kutia,
411
since there is an order of this court, I will not say anything for the present. You produce that order.
Yes.
I mean the
Cabinet
cabinet memorandum.
Yes.
That's an existing
Yes.
piece of document.
That's why I noticed it that round.
Produce it when next Tuesday.
If 1 week time, my lord,
Next Tuesday.
my lord,
The date may be fixed, my lord, because
Yes,
petitioner will be retiring, my lord, next January.
third Priti Chakraborty Planet Farm for the petition. Also heard. Yes. So the petition is going to get for the state and Priti Nath. Planet Farm for the number 5, 7,
4, 5, 6.
4, 5. Yeah, that is not, however, submit that there was a direction of in order that it can it for production of cabinet memorandum and if possible, comma, the proposal regarding the announcement of age of professors after age of 65. The President State Council for some time produce the concept subject matter for keep and also the fact that beneath the exchange that that it for it on keep on Tuesday next.
Keep, because 38, 1 and 2.
Let it be on third, my lord.
Third is the cannot because
Okay, on fifth Thursday.
30
Thursday.
Thursday, 5th of yes.
Lord, you have already definitely reflected on 3 occasions, my lord, that time has been sought for the.
Yes.
Oh, that's okay. Oh, no. All right.
मैं kindly pass over the matter for traffic.
Senior Counsel Nair is appearing.
What is the matter?
They are challenging DP and the consequent mallet, the imposition of penalty of censure.
What is
Whereas
the charge?
charges are 2 charges, but 2-headed charge. It is this censure was imposed due to my lords. Gross negligence in performing government duty partial. Page 120, it starts at 119. Okay, my lord, if we pass over
What is
page 120, 119. Gross negligence in performing government. The inquiry report my lord, will find that
33? It's of the charge. Now what are the facts? First it is so-called notice. So-called notice.
Chocos note. My lord, Chocos it starts at 52. Allegation number 2, 53.
Yes.
In fact, my lord will come to 67. 67, my lord, this penalty was imposed, whereby an increment was withheld, whereby it was reviewed and censure was increased.
Sir, is
That apart, my lord,
there any procedure irregular?
that they are not able to point out because, my lords, the worst of theory now comes into play because in September 2021, it was in this censure was inflicted, whereas in 2022, my lord was promoted. So because state rules, my lord, state cadre, censure doesn't have any effect as of because he has been given that efficiency bar he has crossed. But consider the prayer of the petitioner is that he is within the consideration of uplifted to the IFS cadre, wherein this censure may act as a hurdle. So, Ranat Senior Counsel on the last occasion, my lord, tried to make out a case that this punishment of censure is perverse.
Vis-a-vis what? Perverse why?
Vis-a-vis that, only that point I could gather from him.
No, on procedural irregularity.
He wants to implore his court to reappreciate evidence, perhaps, my lord. He's on leg in court,
Will have it up-
my lord.
a prayer for it. Yeah. Also, are legal questions. Any person for it's a always
May I please?
Yes.
Matter relates to the promotion of the petitioner lordship. Lastly, petitioner was promoted in the year 2005 lordship. Thereafter, petitioner was never promoted. But the juniors are already promoted. We have the annex.
you want to be promoted to which caste?
He was presently
Presently you are
working
serving as
as a UDA account. His next promotional post is senior assistant account. So to kindly see page number page 58 and exercise 17.
where you considered.
No, Lord,
You're not even considered.
not considered.
Did you consider him?
My lord, he has not been considered. This case that he was in the gradation list, he was ranked 132, my lord.
120.
132.
Yes.
Page 47, Lord, you
Did
kindly.
he come under the zone of consideration?
My lord, for that,
You have not filed your affidavit.
No, Lord.
File your affidavit.
Earlier occasion, the director was given to them, Lordship, to produce the departmental promotion committee reports, Lordship, to PC.
If the matter was discussed just once, notice was issued on the next occasion, you were not present. File your affidavit. Or keep it off. Whereas, but yeah. But get the instruction whether he was considered at all.
Obliged.
May I please allow? Lordship, here the petitioner has been selected as the assistant professor in Assamese Lordship in Dutiagan College against PWD quota. As per the disability certificate, her
You filed your
disability
affidavit.
40%. No, Lord.
I need some time, Lord.
File your affidavit. Third, MS, third, for the error. If the sending of clarity.
Lordship.
Madam, you're also there.
Health department.
Health?
Yes.
File affidavit.
Yes, Lord.
We will learn concept clarity in NMS D Boda, sending of health and welfare brief and are granted file.
Date will be fixed, Lordship.
File it,
Already selected, but not.
file it. File it, then we'll have it.
Problem.
What is,
Yeah.
yes,
They were required to produce the earlier
yes, this is the,
inquiry, and
this is the,
he was here in the morning. He was there
Who?
before lunch. Sharma, Miss B. Sharma. He was there.
B. Sharma.
Record time. But I
What's the matter?
My lord, here there were two court of inquiries, my lord, where alleged there were two court of inquiries on anonymous complaint. The first court of inquiry having acquitted me, they now propose to set up a second court of inquiry, both on anonymous complaint. Our
Oh, he has raised a preliminary objection of letter.
later jurisdiction also, because I was serving here and the court of inquiry is at Ladakh,
You had referred to Kusumikno.
Kusum Ignath, my lord, and he had to produce a document to show what was the
When
first.
can we
court of
have? Day
inquiry.
after tomorrow
Day after tomorrow.
or next?
So the
So, our, Friday?
the interim continues.
Right, what the past?
Wait, please, Your Lord. My Lord, a departmental proceeding was initiated, and thereafter, my Lord, the inquiry report being in his favor, my Lord, the disciplinary authority.
Just your instruction.
Instruction awaited, Your Lordship. Kindly grant us 3 weeks time. In this matter, P. Nayak is appealed to.
For finance, but
Finance.
matter for Serbian law. By the referee. No, is not by
Right.
Serbian.
My Lord, on the last occasion, Mr. Rajiv Porpurjaji appeared, my Lord, Lordship will kindly see order dated 38/2023.
38.
And Lordship was fixed the matter today and did not pass any interim order with the understanding that today the matter will be disposed of. Because, my Lord, the disciplinary authority, without disagreeing in writing with the findings of the inquiry officer, has dismissed me from service. So, considering the seriousness, Lordship directed,
No, it is to notice.
my Lord.
When it is noticed, there is no observation regarding matter taken about. Let them serve
Yes, I will serve, my Lord. Wait.
first we gave a word that in this case, not that
I have filed and have extra copy to Mr. Rajiv Porpurjaji on that day.
he does £100 getting for finance department, however, some time not for file period. Madam, your different. MS £100 preparing for he, however, that not also heard children for number 5. Now, the patrolling £100 for the petition. 100
By tomorrow,
by tomorrow. List after 3 weeks to enable file obtaining instructions. That's fine. If the issue is the law or the point of law, we can
covered by Kunj Bihari Mishra, my Lord.
May I please, my lord? My lord, this relates to my lord, claiming here is two issues, my lord. My claim is, first issue is, my lord, my bequests has not been paid. Dismissal period for the bequests for the dismissal period. Second is my lord, the impugned is page 149. My lord, I was, my lord, dismissed later on by this honorable court, remanded the, my lord, that by setting aside the dismissal order, remanded the matter, and which to give, my lord, fresh look on the, my lord, punishment. The with regard to the punishment, my lord, I have been punished with, my lord, by withholding one increment with cumulative effect under the provision of Rule 7(3) of Assam Disciplinary Appeal Rules 1960. These are the two punishments I have challenged. And second part is, my lord, my bequests for the dismissal period. These are the two only. And first of all, my lord, Rule 7(3), my lord, your lordship may kindly see the impugned order first, page 155.
We are taking up for disposal.
Yes, my lord, because of reading.
What are you? What are you?
I was upper division UTA, my lord, in the pension department.
Senior
Yes.
thereafter,
My lord, on 15/2/2015, I was dismissed from service.
Okay.
On 19/2, my lord, 2015.
19,
Yes.
after a DP.
Yes, my lord, after the DP. Prior to that, I was suspended, my lord. Yes.
Thereafter, what happened?
My lord, 19/2/2015, I was dismissed. Thereafter, I challenged that, my lord, dismissal
Where
order.
is the
That
order?
Page. My lord, your lordship and page that, my lord. This is, my lord, page 120.
120.
Yes.
Dismissal order.
Yes.
Nineteen two 2015.
Yes.
Yes.
This was challenged, my lord. Appeal also dismissed, my lord. And later on,
Departmental appeal also.
yes, departmental appeal was also dismissed. I challenged the, my lord, before this honorable court. This honorable court has.
You filed FPP.
Yes, my lord. I filed
Number?
my lord, WPC number. Yes. 3272.
32.
72 of 15. 3272 of 2015. That is page 132 is the, my lord, judgment of
3275.
3272.
How?
2015, my lord.
Then what happened?
This was disposed of on 15/5/2019.
5.
Yes.
Page.
Page, my lord, it is 132. Is the
What was the
direction was, my lord, the dismissal.
Interfered.
Yes, interfered. Dismissal order was, my lord, satisfied. Remanded back the matter to the disciplinary to re-examine the punishment and pass the appropriate order.
Yes. Where is that?
That is page 132, my lord. Findings, your lordship, from 140, para 11 onward.
Yes, one forward, where is this one? Because this is most important part, my lord. Para 11, man. It is further seen from the inquiry conducted by the Secretary to the Government of Assam, Director of Financial Inspection. The persons found responsible for the fake family pension proposal of MS so A. Rafizuddin Ahmed, DIS North Salmora Abeyapuri, B. Ilamuddin Ali Ahmed, Senior Assistant of the so C. Saket Hussain, Dealing Assistant of the Office of the Director of Pension, Assam. I was not there. Subsequently, Saket Hussain was arrested by CBI and put in jail, but subsequently he was reinstated in service on 18/1/2014 by the parent department, that is Secretary Administration Department. However, the petitioner was not found guilty in the aforesaid inquiry. However, in the departmental proceeding, the respondent number 3, after discussing the evidence, arrived at a conclusion that there was a clear violation of established rules and procedures, not only on the part of the concerned officer, but also on the part of the Director of Pension and the EFAO of the Director of Pension, who should have examined the pension paper proposal truly. While deciding search number 5, it was held that the search was partly established by holding that petitioners should have pointed out the delay in submission of the fake pension case, and that the said action on the part of the indicate lack of responsibility and lack of probity. It was also held that Exhibit 2, 3, 4, and 5 indicates that such cases were actually processed, and it was further held that underlying fact was that there was no established procedure while disposing all family pension cases and their service pension rules 1969. Thus, only on the inquiry report dated 26/12/2012, but in the departmental proceeding, the authority, including the respondent number 3, had imputed collective failure on the part of the petitioner, finance and audit officer, and director of pension to adhere to the rules. Para 19 is similar operating code. Matter remanded. Matter remanded, with all earlier orders have been set aside. Matter remanded. The matter is remanded back to disciplinary authority to re-examine the punishment inflicted upon the petitioner afresh and to pass appropriate orders in the case of the petitioner without being influenced upon the 3 orders which have been set aside.
What about the observation task?
My lord, that I'm coming to that.
Not be entitled to back.
Yes, my lord. It is, but that is the issue, my lord. In order to facilitate the same, your lordship may kindly see the paragraph preceding to that, my lord. In the same para, in the page 143 last line, my lord. In order to facilitate the sum, the petitioners shall be deemed to be in service only for the limited purpose of departmental proceeding from the date of dismissal from service till the date of fresh order is passed by the disciplinary authority. This was observed for the purpose of discipline petition. It is further provided the petitioners shall not be entitled to wages, but he shall be entitled to petition to notional benefits for pension and other retirement benefits. My lord, what did my lord, the issue? This is the issue, my lord. What the my lord, government has taken stand in the WS in their written, my lord, in their affidavit. In their affidavit, they have said, my lord, as the High Court has directed. So otherwise they have no problem, my lord. That is the only issue. So as this issue has come forward, my lord, in the my lord impugn order, your lordship will find 145. It was not stated due to High Court's order, man. So I made an inquiry by filing an application why my lord back wages has not been paid. Then only in 147 they have stated, as per the my lord, the High Court order, we are not providing that. That is 147, my lord. Page 147. Then I prefer a my lord review petition before this honorable court. This honorable court
In the review order, my lord, the review order is at page, my lord, 148, my lord.
Huh?
148, my lord, review order. The operative portion your lordship will find from para 4 onwards, 150.
On 40.
140 para 4, 150, my lord, para 4.
Yes.
The learned counsel for the petitioner has submitted the state order contemplated. Yes, the last one, para 6, my lord, 151. That is the, my lord, review order, my lord, operative person. Yes, my lord. The submission of the learned counsel for the parties have been given due consideration. From the nature of submission made by the learned counsel for the petitioner, it is apparent that order impugned here does not suffer from any error from the face of the record, merely because the competent authority have taken action, which according to the petitioner was not the intent of the purport of herein before referred judgment and order dated 15/5/2019. That could not be basis to arrive at a conclusion that review is necessitated because of the discovery of new and important matter that came into exercise subsequently, or that there was any mistake or error in the face of the record. Hence, if aggrieved, the subsequent orders has to be challenged by the petitioner in own merit, if so advised. Therefore, if the petitioner finds himself aggrieved by the order dated 30/2019 passed by the respondent number 3, it is made clear that the observation made by the court in the judgment and order dated 24 cannot stand in that way. So the Honorable Court has clarified, my lord, it will not come into. So it is clarified.
What?
Clarified, my lord, that it will not come into effect.
What is not?
The order dated, my lord, the particular order dated,
That's not interpretation. You thought review, cutting
Yes.
back pages, that has been dismissed. Court has said that if you want to challenge
Yes.
new order of penalty, then the earlier observations will not come into it. That's not have it to observation cut back pages. That was in fact modified by the order passed the review. You thought for back pages. That has
Yes,
been
ma'am.
dismissed. And take that you have been given liberty to make a challenge to the press order if so advised.
Yes.
And that would be decided on its own merit.
Yes.
That's the purpose of
Like the review and the writ petition order, if they wanted, they would have just appealed it in the High Court division bench. They would have wanted.
That was
even without the order of review
Yes.
or the order of judge. Back difficult, as you know. At time we find that the dismissal is put without jurisdiction or it has been done with the intention to cause harm without any material. Then some percentage. But there are materials that on procedural ground or something else. So for instance, normally back page is not given.
That
An
is-
exception 25%.
what
Here it was specified that back pages were not entitled. And your attempt to get it reviewed was not successful. So what is your other prayer?
other prayer is, my lord, first of all, my lord, this was the main issue, my lord. In fact, my submission was that, my lord,
Trying your mode of challenge perhaps not correct. Yep. You that step in at least point challenge in a higher.
that is
You
always
tried
given.
review. Okay, no problem. But you have failed. If that standing gets failed, not for us to reopen a matter which is decided. Is there any other relief you are seeking?
Other relief is, my lord, the punishment.
You're challenging the new punishment. What is the punishment?
Yes, punishment. punishment because
What is the new punishment?
new punishment is, my lord,
Where do you?
lord will find, my lord, that is
146.
156. Yes. 156, twofold, my lord. The punishment also twofold. Yes. And this, my lord, your lordship will find the, I don't know under what provision this has been honored.
30th of August.
Yes, my lord, 30th of August 2019. In compliance with the above Honorable High Court order, the matter has been re-examined and revised penalties awarded to Sri Bimal Paing by withholding one increment with cumulative effect under the provision of Rule 7, Clause 3 of Assam Discipline and Appeals Rule 1964. Yes. My lord, in fact, this cannot be provided because the Rule 7(3) does not provide any matter withholding of any increment. But what you will find it is the 1964 rule.
Increment cannot be withheld.
Without Discipline and Appeal Rule 1964. Rule she does not provide that murder penalty.
Wrong put.
That's why, madam. Because
Page 433 in the book.
Come to 7.
yes, 7. One is
Withholding
increment
of increment.
of promotion. Rule 3, recovery for pay of the whole or part of the pecuniary loss caused by the negligence of receipt of orders to the government of Assam or the central government or any other state government or local authority.
Or possibly, or your lord.
Then
I also thought that this same one, your lord.
they move.
Or to get. But this not
Yes.
you have correct over the rule does not happen. Normally, withholding of increment is one of the penalty.
Yes.
There's no.
Or it should have been probably or promotion.
Or
Maybe there is
Or
a typical error.
you taken the net.
That's
Yes.
first one. Thank you.
The Mohantra is some other. We would have asked you, but we do not want to disturb. You are somewhere else. Physically, you are here. Too much of running in the morning is not good. Cycling is also not. You sleep till 9 o'clock. in the morning. So, doctor, just check here. This discipline appeal rule. Rule 7. 7(2). Is it on or off? Off. Off doesn't make any sense. the source?
No, that is the issue, Your Lordship. What Your Lordship has
What is the source? What is the site?
gazette. Gazette.
Try to have a look at the gadget.
It's not gazette.
Okay, but what are your certificates from?
No, no, my case is that your lordship may kindly, that's why I was quick to the judgment of this honorable court in the previous
Not
judgment.
the judgment. We want to hear the grounds of that.
Yes.
You are aggrieved by an order by which you have put the pen.
Yes.
But is there any defect in the procedure of the DP? Number one. That perhaps cannot even base now. Because this special order was the subject matter of challenge.
Correct.
And those have been examined and the matter was remanded on the part of considering the penalty.
Penalty court. Penalty.
Procedural part, the court has said, okay,
Yes.
we cannot re-enter that
Re-entered.
area.
Well, there is a clear finding of this honorable court.
What
Yes.
is the charge? You can argue on the proportionate effect.
Yes.
What
Yes.
is the charge?
Charge was your lordship. That's why, my lord, in the earlier judgment, everything has been discussed. Everything has been discussed and it is found, but there is no fault on the part of the petitioner. There is not a single my lord fault. He has been singled out by the department for the purpose of.
But Mr. Pai, having said that, the court would have said that we are interfering with the penalty. Court has not said. Court has said that we remand the matter back for consideration of any other matter. That means the court has not accepted the submission that you should be exonerated of the charge.
That is the issue, my lord.
After that, your scope of argument is very less.
So I've got a very old version where it is or. May I give it?
Or cannot be off. Even the same elementary language in our High Court 67.
Second thing, my lord, my lord, it is admitted in the my lord their affidavit that during this period, my lord, if prior to the dismissal, I was suspended. And suspension period has been regularized with all effect. My lord. There is no question, nothing has been, because as per the FR 54, FR 54, my lord,
Suspension was regularized when?
my lord, just now, while by this impugn order, my 146, page 146, your lordship may kindly say the last part. On the last part, it is further decided to regularize the suspension period. And after the punishment, it is further decided to regularize this suspension period with effect from so and so to so and so, treating the pay period as on duty and counted for all purposes. So this has been done under the FR 54. This admitted position, this was done as per the FR 54. FR 54. This can be done only, my lord, if it is the FR 54B 3 and 4 is applied. Because it seems that it is fully exonerated. However, the period with effect from so and so to so and so, joining the regular treating the
Regularized as without pay. There should not be any break here. That's the
my lord, it is further regularized the suspension. Suspension period is, my lord, with pay, with all effect. Suspension period. It is further decided to regularize its suspension period from so and so to so and so, treating the period as on duty and counted for all purposes. All purpose. There is no. However, my lord, the termination period, dismissal period. However, the period with effect from 19 to 2015 to date of joining shall be regularize treating the period as on leave without pay.
So my submission is that, my lord, apart from that, it is also admitted by this that I have been regularized under FR 54, my lord. May I, my lord, show your lordship, FR 54, clause 3 and 54B, clause 3 and 4, my lord. Yes, FR 54B, my lord. These two 154. Yes. Your lordship may kindly see 54B4 first, my lord. On what circumstances? In case of trading under sub-rule 3 of the period of suspension shall be treated as period spent on duty for the old purpose. In my case, my lord, FR 54B4 has been applied because creating the duty for all purpose. This can be done if it, my lord, tells under FR 3, my lord, FR 54.3. FR 54.3 says when the authority competent to order reinstatement is on the opinion that the suspension was wholly unjustified, the government servants shall, subject to the provision of Rule Sub-Rule 22, be paid the full pay and allowances which would have been entitled had he had not been suspended. So, my suspension period is wholly unjustified. That is clear. So, I have been given benefit of FR
Everything.
54 before. So, my lord, now, my lord, if the dismissal subsequent to the, my lord, same transaction on the basis for which I was suspended, if suspension is unjustified,
No, suspension is only the disciplinary inquiry.
my lord,
Suspension is for nothing.
my lord,
Suspension can be a deemed suspension.
definitely,
Will not put the merit to the charges. Examining a suspension.
my lord, what my submission is that it is in the same transaction after suspension I have been dismissed. If suspension is unjustified, dismissal cannot be
No,
justified.
no.
Because
Suspension is on a different consideration at all. It is only the delinquent out of the office. So that the disciplinary proceeding can be conducted in a fair manner without being witnesses being hampered or evidence being hampered or witness influence.
my lord, may kindly see 54, 54,
Interference with suspension we have for nothing.
54 3, my lord, may also kindly see 54, 54. Yes.
That because voting declaration mean a declaration for all purposes. Any case law you are applying
to that effect, my lord. Because
support of your
that is another issue because, my lord, the learned, the single judge earlier judgment is there. So I cannot go beyond that. That is another aspect. That's why.
yes, Mr.
My lord, only one thing, your lord, just I want to point out, my lord, before going to that. 54.1, my lord, 54.3 may kindly see, my lord. Because, yes, my lord, absence period has not been
Is
distinguished.
there any other consideration the bank or learned counsel arguing? Is also bank. There is no consideration.
My lord, may kindly see.
Let us not do not dismiss out.
Yes.
Yes, Mr. Adari.
Lordship, what your lordship has initially said was the same. So I was also planning on arguing in the same manner, your lordship, but your lordship has already
Your argument has been done by the court.
lordship. Because initially the review order does not reveal that it was somehow it was interfered with, or somehow the original order was changed at all. So the backwages remain. So the court, the respondents have only followed that order and then given the
Mr. Bank, your review was for what purpose? only for the
Review was
purpose
only
of
for that purpose of my lord
back
the
quiz.
back quiz. And the argument was my
So
lord
it's a
the
very tight. Okay. Third, the point.
my lord, that my submission is that if your lordship going to, because your lordship is going to dismiss, so that I can go for appeal of the earlier judgment as well as my lord.
That
No, my
the
lord,
time question of limitation.
yes.
We cannot extend. You can best say that you are take 14. 14 also you cannot. This is not a wrong forum or forum order. When can you take 14? Benefit of 14, Limitation Act. When you are pursuing your remedy in a forum which has got no jurisdiction, your review is not a it's not, not. But try. Does that come into the way? Make an application for continuation.
That argument, my lord, the
The initial judgment
it should
has
have been
to be that has to be fed by a hand.
my lord.
The initial judgment for review will have to
When I finally review my lord, my impression was that the honorable court is going to accept it, my lord. In fact, it was accepted almost. But
if it was not when it was not accepted, why didn't you file an appeal? Review was when? Review order was 24.
Yes.
And filed this December after around 8 months. On that, your direct there.
And my lord, in the earlier judgment, my lord,
Because the observation shown not come up.
no way come up, my lord. Even in fact, my lord, this the Bequizes was not a pleading, neither a pleading from the petitioner, nor a my lord, objection from the state. It was only in the last line that observation was done. Nothing is there in the my lord judgment inside the. So my impression was that that was not for the purpose, that was only for the purpose of my lord disciplinary process.
The issue is that now your lordship, if your lordship insists, so whatever passes an order on merit, what will happen to him so far as the first petition is concerned?
That we are not
Your lord, as the planet single just has already passed an order in that case, so we are not. Then also that I can go.
an order of dated by which the disciplinary authority has imposed name copy of one in which in respect is subject that there is a checkered and checkered is including us litigation from convenience. The fact of our the petitioner is serving was serving as senior Department of Government. Disciplinary procedure was in the petition on certain charges regarding genuine of family prior to which and the petitioner was also given by order 15/5/2013. The state it had calculated an order in 19 to 2015 by which the petition was dismissed from service. The Department of Third was also rejected by order 16/5/2000. The state order were supplemental health in a reputation filed with which was considered as the fifth street this court of the part has asked an order dated 15/5 whereby penalty of was interfered with and the matter was not for us arrest of penalty. Court had also directed that not be entitled to back, but you decide promotional benefit or pension and other return that already the open part of effort that expected. Please have a seat. On such mark, the commissioner of election had passed and ordered it 38 by altering by new penalty named top is the one with subsequent by order 12 comma petitioner was placed not at to attack the petitioner had enough by reviewing of one of this court, however, by the above fear. However, by court to the petition to challenge press order of that I have heard to be by for the study that another for it one whereas the fine but define the learned counsel for petition has fairly sub that the scope of challenge is limited in view of orders of passed in W 3 to 7 and the review one of however by referring Assam Services Secretary and Epic rules of my submit should we record submission of for
No, it's not necessary. My lord, only your lordship may clarify that it is not under rule 3, my lord, because rule 7(3) will recover you.
submit that cannot pose those stated to under rule 7 3 comma a reading of the state provision does not would not substantiate the contention of the penalty order as no such penalty is prescribed under rule 7 3. Second take comma that council submit the Learned Counsel by referring to part of the order dated 38/2019 whereby the period of its suspension from 15/5/2013 to 18/2/2015 has been regularized for all purposes. There cannot be cleared in while regularizing while reinstating the petition wherein only notional penalties have been done the learned counsel further submits that in the definitive proceeding, none of the charges be established against the petitioner, and therefore, even if the student has not at least denial of tax till the period of would not for contract other has submitted that the present challenge and if you did not be maintained, would not even be maintained in this period as issue was already determined by this the earlier round named WP 3 to 7, which was put up by ordered it submits that operating judgment there is a clear direction that while the matter was not only for the purpose of consideration of aspect of an of the petition not when back the contention of the state of that since the effort that was not further challenged common, it would not lie on the part of raise the same for a coordinate. He also sub that rejection of review petition one of it by the order 23 has made case of more thereby it clear for you of that part just it is 2009 start back with was checked and the order passed the dated 23/4/2021 was also not further checked and appeal. With regard to ways that the issue Senate does not comment with the provision quoted in Rule 7, Section 3 of the Learned Counsel that wrong quoting of provision of would not affect and an examination of relevant rules would do that penalty is under Rule 7. It also that since was subject matter of the order in which the interpret was only on the aspect general of the legality of cannot be a duty and duty. The rival for the party. Certain facts which are not true are required to before taking up the which arises for it. The discipline is which had culminated the order of dated 19 was subject matter to treat the of the state as such was not justified by this in the judgment that 25 and different was on issue of imposition whereby the matter was run for a reconsideration of the for the judgment that 25 there is a clear that the person shall not get the back and this that is not subject and but if refute application file is reviewed the one of the one in respect of the effort that observation these entitled from back was by the order did 23 4 they wrote not the of it, but the present order dated 38 by which penalty of stoppage of one which had verified that by suspension rate from 15,000 to 18 to 2015 was regularized for all purposes. Period from 19 to has been regularized only for the purpose giving consent but as give without the aforesaid order dated 30/8/2019 is certified by part of six responsible by the that was not read in text as per direction of this book. Just this book is of that under the effort on this back, comma, whether and the relief can be done. Is itself is itself out. The legality as validity of the cannot be gone by this as the same on subject matter the earlier by the order it 15 and the state order had attained as there was help by effort and effort. So in the order it 23 this court had not put to the in the group one of challenge the present penalty order with the third the ground of challenge does not appear to have why wrong putting of a provision of law has cannot be paid as substance such powers are available. Now, such penalty is prescribed under Rule 7, small 2 of the rule. The argument whereby the action of the authority in equate a period of without the period after cannot accept object of the is only to keep a delinquent away from the first of fair thereby the scope of temple is reduced. Further, there is an order of that not and then to back on his feet. And until it of the help of the scope of that to the that is in that the back the that and it is
Okay. But only one line method, because the review order has not stated only on merit. If the petitioner had himself agreed by the order dated 30/2019, entire order passed by the respondent number 3.
review was dismissed.
Yes, review was dismissed, and I was
Liberty was only given challenge. You have done
challenged
it.
the order dated 30/2019. No, my lord, your lordship has observed because of that, but if your lordship omit, because the my lord,
That is
only on
not the correct,
penalty,
that
not
is not the correct construction.
I'm not on penalty, only on the penalty. Challenge the order dated 30 penalty of the 30/2019, not the penalty, but the entire order. That is my submission. Entire order.
Okay, we'll
That not.
May I please, Lord? My lord, the petitioner was retired from service. After completion of the 30th match. Otherwise,
Unsupervised appearing is still left
Oh,
the
that's
airport.
good.
bar. Still left the airport.
hearing matters.
They were supposed to
Most
take
of the matters, I
they were supposed to take time, lordship.
have it filed or not?
affidavit has been filed, my lord.
Filed.
And
Yes.
this matter has already been settled by the Honorable Meghalaya High Court. And in our High Court, my lord, it is pending before the division bench. And in the hearing list, my lord, so it is likely to be this short time. This matter will be taken up to similar matter.
What?
In our High Court, my lord, and Meghalaya High Court has already been settled.
Your view,
Yes, ma'am.
view, all also record your MS unit. This after 4 weeks. However, and granted by the honorable part the people mentioned
Highly.
May I please? In this
Yes.
case, well, pursuant to a disciplinary proceeding, well, petitioner upon petitioner a penalty was imposed. That is, well, time scale of was reduced from 60,400 to 58,600. So this is the well, penalty, and that the departmental proceeding was initiated against the petitioner on the ground that well, a complaint was lodged by the well, petitioner against another his colleague, and that After Millard inquiry, that complaint found as a Millard false one and false. For that reason, Millard departmental proceeding was drawn against the Lordship. Millard before Millard show was notice.
Affidavit file.
Yes, well, it is a complaint.
My lordship, for the record, my lordship, I have kept it yesterday. So it is in the sometime.
What are your grounds of self?
Millard, yes. Millard, that complaint was Millard substantiated one evidence. That evidence was not considered by the Millard departmental authority, departmental proceeding authority. That's why we are before the honorable court. And accordingly, Millard, inquiry officer also not examined before the Millard departmental proceeding. Inquiry officer who conducted the Millard preliminary inquiry, that officer also not examined before the Millard departmental proceeding. As Millard, we
That is the fact finding.
yes.
Weren't you given the scope in disciplinary proceeding? If you had not examined, that would not be taken into consideration. But there's a fact finding inquiry. You're given scope to cross-examine the witnesses, put your own words.
Yes,
What are
well,
your grounds of challenge? Procedural defect or substantial defect?
Yes.
What are defects here?
yes, Lordship, those Millard, evidences examined Millard, by the preliminary inquiry officer, that Millard, that evidences are not cross-examined for the Millard departmental proceeding. That opportunity is not provided to the Millard petitioner.
Those examination, those evidence has been taken into consideration in the while posing the penalty.
Yes, Millard, that were taken into
Let
consideration.
us where is the
Lordship, page 26 is the Millard complaint which were filed by the Millard. Kindly have a look. Yes, Millard, this is the complaint lodged by the Millard petition.
Yes.
May I read, Millard? Would you respect and humble submission number so and so Inspector Executive G.K. Mandal back to state that following few lines for your kind consideration and favorable order, me please. On 18/6/2021, my wife was deployed general shift at civil maintenance from 6:30 hours to 1500 hours. On that day, about due to heavy rain, forget raincoat and scooty not working properly. My wife was unable to come from duty place to her residence. On 18/6/2021, about 15:40 hours, she called me from civil contractor named Hemanta Bora, nickname Rinku, mobile number so and so.
okay, you had made allegation against Tulsi Gogoi.
Yes, ma'am.
Thereafter,
Thereafter, that complaint was substantiated by page number 27. That is the statement of Mr. One Hemanta Bora. May I read? On 18 June 2021, at about 15:36 hours, while I was at the gate of the civil engineering department and it was raining heavily, Mrs. Suspita Mandal requested me to make a call in mobile number so and so, which belongs to her husband, Mr. G.K. Mandal, as she has not brought any raincoat to be used in the rain and to go to her residence after the duty. So I called Mr. G.K. Mandal for Mrs. Mandal.
okay,
Then, my lord, this matter was inquired by the authority, and then as my lord, department was drawn, that my lord, that was false. That's why my lord,
now department proceeding against Tulsi was drawn.
yes, my lord, that page is my lord 28. Page 28, my lord. This is with reference to your complaint against number sons against Tulsi Gogoi, submitted to Senior Commandant CISF Unit Oil Duliajan on 2/7/2021. The matter has been examined by the competent authority and discrete inquiry was conducted into the matter. The following facts and observations have come to light after inquiry into the matter. Number one, the recording of the call between Inspector Executive Tulsi Gogoi and Hemanta Bora submitted by you was incomplete, and later the complete recording of the call was received, and it was found that you had yourself asked Inspector Executive Tulsi Gogoi to enter into the matter of some outsider dropping a lady force member in the Surakshanagar campus. It seems that the recording was manipulated on purpose to suit your agent. This is the
point that number 2, the conversation shared via pen drive suggests no foul intention to insult the modesty or harm reputation of LHCG.
And what is
Yes, well. Thereafter, my lord, one reply was made by the my lord, petitioner on the basis of that my lord, final order was passed by the disciplinary authority. And memorandum of charges was framed by my lord, Annex 6, page 31. Okay. Page 32 is the my lord, charges. That CISF number so and so, Gautam Kumar Mandal Industrial Sector.
served your by your defense team?
Yes, sir.
There-
The final order was passed.
Inquiry?
Inquiry was conducted, my lord, it was not with us. But, that our my lord, submission was considered by the well, disciplinary authority on the basis of that my lord, final order was passed.
Where is it that we are not allowed to across? What is this? You have not been to. Where is your statement of defense for the final order?
Yes, Lord.
Where is your reply to the
Well,
inquiry officer report?
inquiry report is no inquiry of the report is not with us.
Why?
There is no supply to us. Well,
So supplied to you.
he may be getting not with us. Well, we could not annex with the petition.
What kind of petition? You have
Inquiry,
not inquired the inquiry officer report. You have not given your second so-called reply. How do you how to base your case? What is your
yes, sir.
to say that we are not even scope to cross-examine the witnesses?
Yes,
And
sir.
in your second so-called reply, you have to say those that yes, witnesses are there. I have not given scope to cross-examine.
Yes, my lord. Page 36, my lord.
36.
Yes, my lord. Point 4. In this regard, I have requested to authority on 9/8/2021 to provide inquiry copies with supporting documents and also mentioned 15/7/2021 as the office letter has mentioned that examine and discrete inquiry. Next, DC executive recorder Raju sir has conducted inquiry in the matter. I have requested against the letter number so and so to provide inquiry copies and other supporting documents for reply, the memorandum and other purpose. In according with letter number so and so dated 12/8/2021, I have been provided only 6 pages inquiry report. That inquiry has done by DC executive recorder Raju sir. But as per on 15/7/2021, as the office letters, inquiry copies and supporting documents have not provided to me by the authority. Every person can get fair opportunity and principle of natural justice to defend himself. But in my case, authority has not accepted my request. This is the ground taken by the petitioner. Page 36. And in consideration, authority mentioned here that is like arrow mark. If, the charge official had acknowledged the aforesaid charge memorandum.
Page 36, which part?
Yes, page 36.
Which part?
Lordship, point 4.
Point 4.
Yes. Just below the arrow mark is there. Arrow. That is the consideration of the authority.
No, point 4, which line?
Yes.
Line number?
My lord, in 1/6 number, well,
I have been provided.
Yes, well, I have been provided only 6 pages inquiry report.
Oh.
That inquiry has done by
That is what yes, we are only on the fairness of the inquiry. We are not going to the matter.
What my what being referred to as the preliminary. There has to be a disciplinary process that is why that is what
Preliminary inquiry, there is no, there is a district inquiry. You cannot even
he
know.
may not be knowing, but
But the thing is that when you are making our foundation based on preliminary inquiry report, and that report copy and those witnesses where they come from.
if I see some those are in the law.
So who are the witnesses? It doesn't matter because it's been a transfer.
Witness the lordship of Deepika Borua. Lordship will allow me what is that?
You just get the instructions from the officer,
Yes,
and we want to know the procedure you have adopted the inquiry, whether the deposition by the witness is the proper initial inquiry. Whether those are pre-recorded, recorded in front of him, that is not our concern. Maybe a pre-record, but was his presence made available to the petitioner? That is what. And he was, if you had deposed before him, the matter has said, yes. But you can also use the pre-recorded statement. But he has to come, the witness. Means it's the inquiry.
Lord.
To face the cost.
Lord.
Was it done on? You have not made out a case. What's your name?
K. Roman.
Roman, where are your statements that you are not going to process of the witness? What are your grounds?
Lordship of
Paragraph 20.
Yes, sir. Lord.
Paragraph, you have to look at paragraph 20 and 21. We do this to what's the penalty?
My lord, reduction of time scale of pay. Reduction of pay, one stage from rupees 60,400 to rupees 58,600.
What post are you holding?
Mal.
What post are you?
My lord, inspector in executive wing. Yes. Is 39 is operative.
We will have it.
they are
tomorrow.
they are
Third, zero. Record have the what will I allow put the
Public.
Lordship, this is a matter regarding minimum age for appointment as the Gao Pradhan. Lordship, in that matter, we are supposed to file an affidavit in reply, Lordship.
File not.
Not filed yet. Lordship, we seek some time, but N.M. Azarbuya. Yes, sir. Yes, sir. 3 weeks, Lordship.
Testimony number 4. M. Salim. Before the vacation,
Is there an interim order?
interviews
No,
are already
interim-
vacated. Because of this case, madam, appointment pending, pending
To write an application that there is no interim.
already submitted application for
You file an I will pass order.
IA.
File your file.